Good morning, good morning, good morning. It's Tuesday. It's October 17th. I can't even believe it. I have so much to talk to you about today. So, replay crew, love you. Everything will be timestamped down below for you watching on replay. Today, we have a very full quick bits, and then things in the Kouri Richins case have popped off. Like the walk the dog letter was something else, but now we have a phone call with her dad. The defense is alleging prosecutorial misconduct. The prosecution is alleging that her defense attorney is smuggling things out of the jail. It's gotten wild. So we have a bunch of documents to catch up on in the Kouri Richins case. Kouri Richins is a case out of Utah, of course, where she's accused of poisoning her husband with fentanyl. That's happening. Then in Quick Bits, we are going to be talking about Sssniperwolf and JackFilms. When does internet drama go too far? What is the statute about doxing in California? What is and is not considered doxing, both in the court of public opinion and the court of law, and what's going on there? Then we need to talk about this Joe Jonas divorce. Have you guys seen the headline saying that Joe Jonas dismissed the divorce? Yeah, those headlines don't read court documents. Legalese is hard, bro. That's not exactly what's going on in the Joe Jonas divorce. So we're going to make sure that we clarify what the news has gotten wrong. And then Joran Van Der Sloot, who has long been believed to be the key to solving the murder of Natalie Holloway, or perhaps the perpetrator of that crime, is set to take a plea in federal court. And we need to talk about what that plea is predicated on. Oh boy. Oh boy. We have so much to do today. Are you guys ready? How many of you are in here from the Law Nerd app? I hope that you're using your 15% off. Just for a reminder, the Law Nerd app has a 15% off coupon that is good through Friday. So if you've not yet downloaded the Law Nerd app, just go to lawnerdapp.com and you'll get it. And you'll get it right now. Just go get the app now while I roll the intro. It's plenty of time. I bet you can have that app installed in your phone before the intro is done. Are you ready? Are you ready? Get on your mobile device. Let's go. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
I hope all of you have fast internet connections. For sure. So today we have quite a lot to talk about. All of it, we will cover. I see that there's breaking Murdaugh news. Chat, if we have time to pull the court documents, we'll get to it. You can see why I don't necessarily trust legacy reporting, but I'll go look. Look, it doesn't surprise me that some Murdaugh fuckery is going to come in and mess with my seemingly well-organized stream that is already too full of stuff to get this done today. But, you know, Murdaugh with the murdacity of it all. So if we have time, we will get to it. If not, we will get to it Thursday. Tomorrow's Emily Show podcast is covering the legal updates for the 8 passengers case with Ruby Franke and Jody Hildebrand. And then Thursday, we will have time for a few topics and, well, a topic. And then we are going to hopefully do a live court hearing if cameras are granted in that courtroom. So Thursday's a little up in the air, but we will see. I'm hoping to bring you live court. So we will do the things. Are you guys ready? Are you ready? Are you ready? Let me know where you're coming in from, what you're drinking. I am rolling pumpkin spice season, and as long as I can. As long as I can. Are we going to quick bit Murdaugh? Let's quick bit Murdaugh. We'll Murdacity. Let me just grab it. Look, this is why we have the internet. So we have time to grab it. Where is... All right. The South Carolina stuff, I appreciate. This is from less than an hour ago. Oh, Alec Murdaugh. She doesn't even go here. And yet it is a daily grind of Alec Murdaugh getting into freaking nonsense. Hold on. I'm going to go check a few sources because every single source every single source dealing with this Joe Jonas stuff is wrong because they're all basing it off of one source, and it pisses me off. Like, the one source got it wrong and they're all like, this other news outlet said this, and I'm like, what are you doing? Like, that's not what it is at all. So let me go and check. Let's see. Chanley Painter is in Birmingham, Alabama for Joran Van Der Sloot, Vander something's last name, Vander something's last name for his plea. So I'll be keeping an eye on Chanley's feed to see what other information we get. And then we are seeing from Court TV and Chanley Painter. Let's go to Quick Bits. We're going to update it from there with 2 quick news articles. All right. Fuck you, Alex Murdaugh. I'm tired. I had such a Tuesday planned, and now you're like all doing stuff. It's all right. Chat, I rather know than not know. Quick Bits. All right. We're going to, my favorite place on earth, the Twitters. No, I can't call it X. It's like we're going to X. It's when people refer to their ex, it's generally not a good thing. Like, it's just an odd thing. It's just an odd thing to me. I can't get used to it, and I'm not going to force myself. I am way too neurodivergent to try at this point. I have given up, and I'm cranky about it. Monica in the chat said, Van Der Sloot pronounced like boat. That was tremendously helpful. I don't know if it's right or not, but I'm going with it. I'm going with sloat like boat. I can do that. Breaking news. South Carolina Court of Appeals has suspended Murdaugh's appeal on the Murdaugh convictions, remanding the case back to the circuit. A hearing is ordered to investigate jury tampering. That's what I was hoping would happen. That's generally what we thought would happen. The allegations are wild enough, and there are those documents from jurors saying this is what happened, that they just need to bring in the jury. They need to literally bring the jury. They need to bring the jury and ask them questions. That's exactly what they need to do. So all this does is give us a hearing that we will hopefully see, that should be very public. We should all see this hearing. But brings the jurors in and questions them in front of the judge to determine if there's jury tampering or not. For those of you that are like, what jury tampering? Here's a quick road so far. It's alleged that the clerk of court tampered with the jury by telling them not to believe Alec Murdaugh, among other things. There's videos up on the channel if you want to go catch up on it. It is quite a saga. So what does this mean? This means that the appeal is stayed. It is suspended. It does not have to move forward. We're not going to see all the appeals. We're not going to see all the appellate briefs. We're going to take this back to state court for a hearing. The prosecution said this might be needed. The defense said this is absolutely what's needed. I am not surprised that this is the result. I think it's the proper result. I think the claims have to be investigated, especially since the claims are backed by at least a few sworn affidavit from jurors. So here's the official statement by Alec Murdaugh's lawyers. I'm sure they'll have a press conference at some point. The recent ruling to stay the appeal and remand the case for a hearing on Alec Murdaugh's motion for new trial is welcome news. We intend to proceed expeditiously. We will seek a full-blown evidentiary hearing addressing the serious allegations pertaining to improper jury communications by the clerk of court. I think that's what needs to happen. I agree. I think that's exactly what needs to happen. I think that when you have a number of jurors swearing under oath, now if they come in front of the court and retract those statements, that's different. But when you have a number of jurors swearing in an affidavit that they saw the clerk of court having side conversations with the jury while it was going on, while the trial was going on, That has to be investigated. It has to go before a judge, and you have to have an evidentiary hearing where people are put under oath in front of the court and questioned by both sides. If this was done, it is not only illegal, but it is absolutely grounds for a new trial. I don't care what you think of Alex Murdaugh. Truly, I love your feelings. I am here for you. But if this happened to anyone, a new trial is warranted if this is substantiated in the way it has been presented. That is a big if. But we need to be able to have a standard, trustworthy system of justice, even when the defendant might not be your favorite human. Because someday the defendant might be you, a family member, someone wrongfully accused, and we cannot have multiple systems of justice. So no matter how strongly you feel that Alex Murdaugh should be convicted, it has to be done properly and procedurally properly. If there is jury tampering here, then the convictions can be overturned. However, there would generally be grounds for a new trial, and it would all be done again, which would be a tragedy for the people of South Carolina who would have to pay for this trial all over again. I don't think that's what anybody wants, but if that's what needs to happen, then that's what needs to happen. So will Alex Murdaugh get a new trial? Well, he's getting a hearing. And is that the fair and just thing to happen? I think that it is. I think that it is. Also, I miss Judge Newman. So on a personal note, I'm ready to see these attorneys again. I thought we were going to have to wait till the end of November when they go back to trial. Excuse me, Judge Newman. I'm gonna email you my dates for BravoCon. What we can't do is this trial during BravoCon lawn things. We can't do this during BravoCon. I'm teasing. I'm not actually going to email Judge Newman. Question in the chat from Allison King. Will it be the same lawyers? Yes. Yes, it will. Would the murder convictions be waived? This is on the murder case. So if they're not waived, but if a hearing is granted, if jury tampering is found, then it can be grounds to grant a new trial, which means that the convictions would be overturned and a new trial would be granted, which, if jury tampering is proven, would be the right result. That means you do it all over again. Cindy in the chat is asking the real question. If it retries, will I cover it? Yep. Oh, yep. Yep, because then we're going to have to cover if rulings are different, if different evidence comes in, if the witnesses play out differently. Oh, we absolutely will cover it again. We got to see Poopy Putin again. Absolutely. Absolutely. So that's what's going on real quick with Alex Murdaugh. All right, let's get into the rest of our quick bits, shall we? From courthouse Becky drama to internet drama that some of you might be aware of and some of you might not be aware of. I'm going to put a poll up in the chat real quick before we switch topics. Have you been following the Sniperwolf JackFilms drama? Beef? Is it beef? Is it drama? Whatever. It's drama. It's gone beyond drama now, but it's drama. I feel like sometimes drama's downplaying it, but I just want to know if you're following it, because some of you, this is your world. Some of you are like, what fucking corner of YouTube are you talking about? Look, man, I was up way too late last night watching someone play video games on stream. That was me. I was one of the like 40,000 people watching Ludwig play this fruit matching game. So a lot of you saw it from Phil DeFranco. A number of you saw Tuzi cover it. Let's go. Let's talk about it. Sniperwolf, which I am told stands for something like super sexy. Snexy's not a word. Super sexy Sniperwolf, is a creator on the platform with like 30 plus million subscribers. JackFilms is a creator on the platform with like 5 plus million subs. JackFilms and Sniperwolf got into internet beef over what is and is not proper commentary and fair use, where JackFilms, it seems to me, started a second channel to take the piss out of Sniperwolf's content, and has issue with whether or not it is actually fair use commentary. So with commentary, and we've seen people talk about this with XQC and other commentary channels about when they are reacting, and this has gotten, I think, worse with short form content, but when they are reacting to content and watching short form content, is it really fair use reaction, or are they just stealing content from other creators and going, wow, cool? Is watching a 60-second video and going, neat commentary? I mean, it might not be transformative commentary. So when we look at stuff like this, the background of this is a bigger fight that's been continuing on this platform. And the bigger fight on the platform is over what is actually fair use commentary. What is transformative commentary? I have a video on this channel that goes all through the elements of fair use in the context of the H3 Matt Haas lawsuit and how judges determine this. When it gets to fair use, here is the problem that the platform faces. And we might have to go back to the Bungie case to look at this too, if you followed the Bungie case. When it comes to fair use, it's a defense, which means you have to have a lawsuit initiated to prove that you are using something fairly. So the copyright holder can sue you, and then you have to prove that it's fair use to defend yourself in court. Sometimes that goes well, sometimes that goes badly. And there are elements that the court looks at that are starting, we see to shift, but it really goes jurisdiction by jurisdiction, judge by judge. There's no like easy rule. And I get asked this a lot, like, how much of a video can I react to? And honestly, it just depends. If you react to 2 minutes of a 15-minute pay-per-view boxing match between influencers, and it happens to be the end of the match and a knockout, it might supersede the need for anyone else to go watch that boxing match. So it might really not be transformative, and it might take the heart out of the thing that you're watching and substitute the original, because everybody's like, oh, I've seen how it ends, I don't need to go pay for the rest of the thing on pay-per-view, right? So there's no right percentage because it depends. Watching the entirety of a 30-second TikTok with critical commentary might actually be transformative, fair use, or educational, but it also might not be. So again, no real hard and fast rule. It just depends what they're using, how they're using it, and what they're talking about it. There's tons of this kind of content across the platforms. There are clip channels that just voice over it. A lot of those channels don't get monetized by YouTube. And then there are these large reacts channels like Sniperwolf and XQC that react to short form video. I don't know if Sniperwolf has ever walked away from a stream and let their chair sit there and react to comment, but we've definitely seen XQC do that. So that's basically where we are with the beef, very, very simply, between Sniperwolf and JackFilms. So JackFilms created a second channel, JackFilms, to take the piss essentially out of Sniperwolf's content, because he states openly and freely on the platform that he does not believe it is fair use and believes it's stealing from smaller creators that aren't credited with the use of their content, which is part of the big issue on the platform. And the argument over this is you're taking the views from the original creator who made the thing, adding 3 words to it, and then going, oh, that's fair use, when it might not be. So he reacts to her reacts and credits the creators. This has escalated to a real world situation when Sniperwolf showed up at JackFilms' house on Instagram and filmed the front of the house to her, 5 million Instagram followers. That has since been re-uploaded around the internet. To the credit of most people covering this story, they have blurred that out so not to continue to put out the front of his home on the internet. We really just saw that with BitBoy Crypto going to the house of a business partner who he had beef with. If you have beef with someone, showing up at their home is almost always going to be taken by the person inside the home as threatening. And it doesn't matter. I've seen a lot of people be like, is he really threatened of her? It's a threatening act, in my opinion. It's like my opinion, to show up at someone's home unannounced and then putting the face of their home, the front of their home on the internet, and then being like, what? I found the internet on Google. So it's showing what the house looks like, showing where the address is. And it's not just about someone showing up at your house and whether they will create an issue, but they've now put that information out there, and will their followers also take that as almost a call to arms because there's this ongoing beef between two creators. Don't go real world with people. Don't show up at people's homes. It is going to end dangerously. And at some point, we are going to see that end very, very badly. And it's not necessarily that the creator would do something, but they've now emboldened, empowered, or incited potentially an audience who might want to do something. And that is deeply, deeply concerning. If someone shows up at my house uninvited, that's not delivering one of my many Amazon packages every single day, that has beef with me on the internet, I am going to consider it threatening. Always. Because there's no other reason to be there and to not go through channels where you can connect to each other to have a conversation. So I understand why JackFilms feels threatened. Do not go real world with people. It is going to end badly. This goes for other creators. This goes for fans. It is not okay. So we're going to go take a look at exactly what the cyber harassment statute is in California and how either of these parties might be able to use these statutes. In California, it should be noted that cyber harassment can be grounds for restraining orders. Is that what these parties need to talk to their lawyers about? I'm sure they already have. But we live also in a country where free speech is a whole thing, even if you don't like the speech. So I understand that Sssniperwolf is like, this person's got a channel dedicated to taking the piss out of me or talking shit or whatever it is. And if that crosses a line, there are actions that can be taken. Those actions are never rolling up on someone's house. But there are actions that can be taken if it goes, if it crosses the line. But again, people are allowed to make comment, and people frequently do. People make true comments, people make wrong comments. People are allowed to make comments. That is part of free speech, even if you don't like it. It can feel harassing. I'm sure it feels harassing to Sssniperwolf to have a channel dedicated to calling them out. I'm sure they don't like it. I'm sure they don't. But is it legally harassing, or does it just feel that way to her? All right, let's take a look at California's actual law and see. Here's where I stand on this so that there is no confusion. Showing up at people's houses is going to end badly. It crosses a real world line that is not okay. We have seen so many creators swatted, which also is very dangerous and can end badly. It is not okay. It is never okay. And then streaming it to your audience is almost weaponizing your audience against someone, even if you don't expressly say it. So in the world of kind of internet code, it's absolutely outside the boundaries of the way people deal with each other. In the legal world, let's have that conversation and see what you guys think of the code. We're going to California Penal Code. I can't make this any smaller. Hold on. Let me embiggen and see if I don't cut off part of the words. This website is so shit, but it's California government website, so I'm not shocked. Oh, wait, if I go to PDF, maybe it'll look better. Yay! Emily, it's not the website, it's you. You are the problem. Hi, I'm the problem. It's me. California Penal Code section 653.2 is where we're at. This is their cyber harassment statute. This is also their doxing statute. This is what it is. Every person who, with intent to place another person in reasonable fear for his or her safety, or the safety of other person's immediate family, by means of an electronic communication device, without the consent of the other person, and for the purpose of imminently causing the other person unwanted physical contact, injury, or harassment by a third party, electronically distributes, publishes, emails, hyperlinks, or makes available for downloading personal identifying information, including but not limited to a digital image of another person or an electronic message of a harassing nature about another person, which would be likely to incite or produce that unlawful action, is guilty of a misdemeanor. So when we're looking at whether or not this is doxing, is it making available personal identifying information? And in California, where someone lives, I would need to go to all of the case law to see how they define PII as your home. Generally, yes, it is. So where someone lives is generally considered personal identifying information, where somebody's business address generally would not be considered personal identifying information. So if the intent is to place another person in fear, is that why do you roll up at somebody's house other than to make them stop the thing you don't like? So not just the safety of the person, but the person and that person's family. So if someone rolls up on my house and my kids are here, it's not just that it places me in concern, it also concerns my children, right? By means of an electronic communication device, phone, without consent, for the purpose of imminently causing the other person unwanted physical contact, injury, or harassment. Is this to harass? You guys will have to tell me what you think, because when you get to things like this, if it goes to trial, that's what the jury's having to have a conversation about. Was this intended to harass? Does this distribute via an Instagram story identifying information of another person? I would argue that what someone's house looks like from the front and telling people where to go find it can fall under this if it were to go to a jury. Can. And then we get to the would likely incite or produce that unlawful action. Can you see an audience of 5 million having a few people that would ride for their favorite creator and issue death threats, send death threats with the front of someone's home, sit outside someone's home and send death threats? Couldn't you see that happening? I can absolutely see it. As someone who receives death threats, I can absolutely see it. If you are blasting that photo across the internet. So you guys have to let me know what you think if you're the jury sitting here. For the purpose of this section, electronic communication device includes but not limited to. Remember, the law defines things. We're going to get to the legal definitions. Telephones, cell phones, computers, internet web pages or sites, internet phones, hybrid cellular internet wireless devices, personal digital assistants. Do you remember PDAs? Not the public displays of affection. Do you guys remember the PDAs? Who had the Trio? Who had a Cassiopeia? How old are we? Video recorders, fax machines, pagers. For purpose of this section, the following terms apply. Harassment, knowing and willful course of conduct directed at a specific person that a reasonable person would consider as seriously alarming, seriously annoying, seriously tormenting, or seriously terrorizing the person that serves no legitimate purpose. Here's where cyber harassment can skate a fine line. So when we're looking at this from the perspective of JackFilms, would a reasonable person consider having internet beef go back and forth on Twitter and whatever, and then having someone say, should I roll up at Jax's house, and then roll up at their house and film the house to millions of subscribers that it now lives on the internet forever? Would a reasonable person consider that to be seriously alarming, annoying, tormenting, or terrorizing with no legitimate purpose? When we look at the other side of this from Sssniperwolf saying, but he's got an entire channel dedicated to making content about my content, would a reasonable person consider that seriously annoying or tormenting? But also, would there be an argument for a legitimate purpose of giving commentary? Where does that boundary of legitimate purpose fall? And could we see both of these parties pointing at the other saying, they're harassing me? So rolling up on someone's house, I think it's a harder argument to make that there's a legitimate purpose for that. You're not going to retrieve something, right? They don't have something of yours. There's no reason to go to the home. They haven't asked you to be there. But I also think that on the conversation of his channel being tormenting or annoying, I think there becomes an argument there where it might have a legitimate purpose for commentary. However, I feel like once this has gotten to the point where she shows up at his house, it makes it really difficult to argue that she felt so tormented or annoyed or terrorized that she was afraid of him because she showed up in his space to confront him, it seems. And so if you're terrorized of someone, do you show up there? Or do you go get a restraining order? But even if you get a restraining order, I don't think you can stop people from criticizing you on the internet, as annoying as that can be, as targeted as that can feel, as unwarranted as that can feel. And the bigger you get as a creator, the more criticism there is. And it sucks. It's not fun. I get that. Every time Mr. Beast uploads a video now, did I say video? Video? It seems that the legacy media is like, Mr. Beast is doing this. Every single time. So yes, that can be seriously annoying. But does video giving commentary have a legitimate purpose versus a video that is showing someone's home, i.e. BitBoy Crypto rolling up on his business partner and Sssniperwolf rolling up on JackFilms? Though I think the BitBoy Crypto situation became more serious than this situation, I still think this can fall under California's definition. Lots of states have very similar laws to California. Some make them aggravated felonies beyond misdemeanors. Let's talk about what of harassing nature means. Means of a nature that a reasonable person would consider as seriously alarming, annoying, tormenting, terrorizing of the person that serves no legitimate purpose. So harassment and of harassing nature are both in there with the same. This was effective in 2010. That's why you see some of the older language with like fax machine. Don't cyber harass people by fax machine. And this is kind of where we fall with doxing, and that's the making available personal identifying information. Does putting the face of somebody's home on the internet make available personal identifying information in a way that could incite or produce unlawful action, further harassment? And again, I can see people using a photo of someone's house along with threats, and that the only intent there is to be terrorizing. And it would be. Having somebody send you photos of your home would feel threatening as a content creator. But it would also feel threatening if you just, have a job and somebody doesn't like the job you're doing and they send you a threat with your home. So I think there is an argument here. Is it likely That anyone called the police? I don't know. Were police reports made? I don't know. If somebody rolls to your house, do I think that making a report is needed in case anything escalates and there's further harassment? Absolutely. Can this be prosecuted? I would want to talk to everybody involved before I would make that decision, but is there a law that can prosecute this under a misdemeanor statute? Yes. Can this also be grounds for getting a protective order, stay away order? Yes, it absolutely can be. So with this whole situation, don't go real world with people. And you guys can let me know if you think distributing the front of somebody's house and telling everybody where to go find their information counts as making available this type of personal information with the front of someone's house. You tell me what you think in the chat. I'm going to go take another poll. Some of you have been following this. 64% of you have not been, with over 4,000 votes. There's 7,000 of you here. Let's do one more poll. Under this definition, chat, you're very reasonable people. You're uber reasonable. Do you think this violates the code? 653.2. Given the facts that we know today, do you think this violates the code? Let me know. All right, chat. We are going to move on. My position on... Oh, I did this wrong. Hold on. I did this as a Q&A. I meant to do it as a... I meant to do it as a poll. Emily, hit the right button. Under California Code 653.2, do you... All right. Under California Code 653.2, do you think Sniperwolf violated the law? You let me know. Do you think the actions taken fit this misdemeanor code statute? That's what I want to know for you. If you ever need to look up the law, California has the California Legislative Information. It's literally leginfo.legislator.ca.gov. These things are pretty easy to find. If you go to Google particular laws, always try to find the government website that has the laws. A lot of law firms will put up information about the law, like California's doxing law is Penal Code Section 653.2. Go read the code next. That's my suggestion. Go look at it and see if you think that these actions meet these definitions from the standpoint of a reasonable person. Don't go real world with people. I don't like it at all. You guys know how I feel about that. It doesn't matter how vehemently you disagree with someone. There are still boundaries of a civilized society that should not be breached. And going real world with people is dangerous for everyone involved. And I feel like society has become more tense, not less, and that people are more likely to have confrontations, not less. And then if you include time of day, I believe this was after 10 o'clock at night. If you include time of day, it becomes even more threatening. No one is chatting with me at 10 p.m. except my spouse and my kid, who's explaining to me why he needs to continue to be allowed to play Cyberpunk. You know, being like, Mom, I'm just going to play another round. And I'm like, buddy, I need to continue watching like fruit match games on live stream on YouTube, but I need you to go to bed. I need you to make better choices than me right now, kid. I need you to go to bed. So I need you to stop watching fruit match games and playing Cyberpunk and go to sleep. So we don't go real world with people. This code section does not just limit it to real world. This also covers cyber harassment. And cyber harassment is something that a lot of people don't go through the lengths to prosecute, but I'm seeing content creators starting to bite back more against those that think they are anonymous on the internet. And I think we are going to start seeing content creators saying, you know what, it's worth the money. I'm done. And there is process. We saw that Cardi B felt very harassed by Tasha K and went and did a full federal trial on defamation and won. Now that takes like fuck you money to do. It does. And that's a very unfortunate part of all of this is it can be very expensive to stand up for yourself legally. But we're seeing it happen more. All right, y'all. Shall we move on? Shall we move on from like, don't go real world with people? It's going to be considered threatening? Right. Let's see. We've got some great chats in here. Thank you, chat. AC Skills says, I read the code on the California government site. I think it does violate the statute. I think there are, and again, we have the information that we have publicly. JackFilms has talked about this on his YouTube channel. If you want to go watch his video about this, go watch his video about this. We've seen Sssniperwolf poking fun at this on Instagram, posting a story being like, roll up on your house, what do you do? So we've seen how the parties have reacted to this. I have not seen if Sniperwolf's fans are going after Jack's films. I have looked at Jack's videos, the stuff on what Sniperwolf has done and said on Twitter. I've looked at Atuzi's coverage. I've looked at Charlie's coverage from Moist Critical. I saw Phil DeFranco cover it, and that's kind of where I've kept it. I have not looked to see if this is bubbling out more on the internet, though I wouldn't be surprised if it's bubbling out more. So Esker points out the Boogie situation. I remember this. Guy showed up at Boogie's house and was ringing the doorbell repeatedly and said on the internet, I'm going to roll up to your house. Different states, this goes differently. It really depends on where you live. You have to know where you live and what the laws are where you live. But I also can't see another side of this. And chat, help me if you see it. And I think because I'm a content creator and because I've had, as a DA, I've had police protection on my house, I perhaps am more sensitive to this. But I can't see another side of how rolling up to somebody's house unannounced at night after telling your Instagram followers, I'm just going to roll up, and then putting their house on the internet instead of just saying, I went, this is what happened, putting their house on the internet. I don't see the other side of how to take that other than it's meant to shut somebody up. It's meant for somebody to go, oh, I'm going to stop making these videos. How else is that intended? Because I don't see how else it's intended. Natalie, absolutely. Everyone should feel safe at home. Absolutely. Absolutely. It is a no-go. It is a no-go. Laura M said, question, can we talk about how she said Jack was defaming her by saying she doxed him? The audacity. I think that's all that needs to be said, Laura. The audacity is correct. That's not defamation because we read the California doxing statute. So y'all get to decide. But it also indicates to me that Sniperwolf, and I don't know how old Sniperwolf is, but that Sniperwolf thinks that this isn't a problem. So these confrontations can go very, very, very badly. This happened in California. This scenario perhaps goes differently in other states. Other states have different rules about people rolling up at your house. She's 30? There are lessons we need to learn in life. And rolling up at somebody's house, a wide variety of ages, rolling up at somebody's house is outside the bounds. Amanda asked, anyone know where the word dox came from? The general definition of dox, yes. Where that originated from, no. But it went to documents, dropping documents on somebody, showing your personal information. Personal identifying information is getting harder and harder to protect on the internet, and we will talk about that in future shows. But this statute particularly says makes available for downloading. So if you find someone's you dig up somebody's information buried deep in the troves of, the gray web, and then link it for everybody and go, but it's available on the internet. In California, making it available to everybody, bringing that up and making it available might very well violate their doxing statute, even if the defense is, but it's on the internet already. That's not going to fly. And this is something that all content creators should be aware of. And if you feel that somebody is harassing you on the internet, there are steps to be taken to ameliorate that harassment. Going to their home is never that step. And especially when I see content creators with huge platforms who I know are making money, the person to have a conversation with this about is first your therapist, and second your lawyer, and third, perhaps a private investigator, to see if this is actually causing problems. If the videos are causing you to be harassed by others, there are steps to take. All right, let's go. Somebody said, let's see, dox is just the verb of dox. Yes. Matt Apple says she has 2 videos complaining about strangers coming to her house, which they shouldn't do either. Right? Should not. YouTube has a content creator code of conduct. I think that this violates the content creator code of conduct and the rules on the platform. Do I think YouTube will take action? I think they'll have to do something to have a discussion, because YouTube can take action against creator for behaviors made on other platforms. Do I think this will deplatform Sniperwolf? I don't think so. There are lots of creators on the platform who have had other and more egregious issues that are still on the platform. Will it take her out of, I don't know if there's a priority program anymore or what? Will it pull her out of some of those things? I don't know. I'm keeping an eye on what the platform decides to do. NCC weaponizing the audience, keeps smaller channels from speaking up. They often don't go after bigger channels. Yes, because a incited audience can cause an incredible amount of harm, even if they are in the right. We saw what a pissed off audience can do when we looked at the beef between Ethan Klein and Harvey Weinstein? No, Ryan Kavanaugh. When we saw that beef going back and forth, and Ryan Kavanaugh was like, but Your Honor, they did all of this. And Ethan Klein's like, I didn't tell them to do that. They were pissed off. And a pissed off audience can do quite a lot. But Ethan Klein never disclosed Kavanaugh's information. Only said, this is what's been in articles about him. So, don't go real world with people. Therapist, lawyer, private investigator. All right. Are we ready to move on? I'm ready to move on. We've got 2 more stories to do in quick bits, and then we have just a metric ton of Kouri Richins stuff to talk about. So, should we talk about the media getting the Joe Jonas stuff completely wrong? I think so. I have no idea what these words mean, Esker. You should look into the Quantum TV's beef with the Act Man. There are so many niche internet beefs. I can't keep up with niche internet beefs. This one is such a large internet beef that my kid was like, did you hear about this? Because my kid watches Moist Critical. Did you hear about this? And then everybody who watches Phil DeFranco, like once it makes it into Phil DeFranco, it's kind of become like a mainstream internet beef. It's come out of the niche communities that know about the beef. There are so many niche community beefs. Going real world is always a problem. Always a problem. All right. Let's talk about the Joe Jonas, Sophie Turner stuff, shall we? Let's all cheers. Let's take a drink. Let's reset. And let's talk about celebrity divorce instead. Joe Jonas, Sophie Turner are in the middle of a divorce that has been filed in Florida by Joe Jonas. Sophie Turner filed in New York regarding child custody. We saw in the New York case that Sophie Turner and Joe Jonas had agreed that they would not remove the children from New York while they were dealing with the case. Then we saw headlines all over the media that Joe Jonas had dismissed the divorce and that the divorce filing had been dismissed. Now, we're not unfamiliar with this in the role of celebrity divorces, that celebrities will file for divorce and then dismiss the divorce and then try to work it out and then refile, et cetera, et cetera. So I think when most people saw these headlines, I'm going to pull up these headlines. When we see these headlines, I think most would assume Joe Jonas dismisses Sophie Turner divorce case. Joe Jonas has filed to dismiss his divorce case. Joe Jonas files for dismissal of divorce. Joe Jonas and Sophie Turner make final custody decision. Yahoo's close. Good job, Yahoo. Joe Jonas files for dismissal of divorce case. Sophie Turner and Joe Jonas are reportedly taking steps forward. She knows better. Sophie Turner seemingly unfollowed. That's not related. So these headlines would lead most to believe, I think, that Joe Jonas has decided to not continue to pursue the divorce. And that's not what's happening. They are still pursuing the divorce. So we're going to do what we do around here. There's times when they're like, Emily, but there's no court filings. I'm like, right, that's why I'm not filing it. This divorce is very much not dismissed. So we're going to pull up the divorce. We're going to pull up the divorce case and take a look. Let's see what the parties filed with the court first. Yes, there is a notice of voluntary dismissal. So if you just read the title of the document on the docket and don't read the docket, I can understand why the media got it wrong. But like everybody got it wrong, except for Yahoo. Good job, Yahoo. Really made me think of you. Go, Glenn Coco. You go, Glenn Coco. 4 for you, Glenn Coco. One of my favorite parts of that movie. Petitioner's notice of voluntary dismissal. But this is where legalese is hard, bro, comes in. Petitioner Jonas, through the attorneys, makes and files this notice of voluntary dismissal of relief requested to parenting. Dismissal of relief requested to parenting as set forth in the petition for dissolution of marriage. The petition for dissolution of marriage has multiple points. They have decided custody. Yay! They've mediated custody. Woohoo! I was hopeful that this is what would happen. The custody has been resolved. Good for them. Yay. But the divorce is still ongoing. So Joe Jonas dismisses divorce, I believe, is deeply misleading because people are going to think, oh, they're not getting divorced anymore. That's not true. They've resolved custody. The parties attended a 4-day mediation during the week of October 2nd and have reached various agreements. They continue to pursue an amicable resolution of all issues in this matter. Good. Go to mediation. As a part of the agreement reached between the parties, petitioner files this notice of voluntary dismissal of claims related to parenting. They have come up with a custody arrangement, and they are not going to need the court to determine the custody arrangement of the children, which means we will probably also see something filed in New York. Resolving the custody means that the rest of it should probably easily resolve based on the prenuptial agreements. And they will determine the amount of, parental financial support that might go back and forth. But they have determined parenting and custody issues. The relief and claims sought regarding to parenting contained in the petition dated September 5th are voluntarily dismissed. All other claims asserted in the petition remain pending before the court. Custody has been resolved. Parenting has been resolved. This is often the part that drags on. I think that they will be able to mediate the rest of this divorce and be done without dragging it through court. I'm hopeful of that. The less that these two parents drag each other through court and through the media, the better for everyone involved, but especially the better for the kids involved. This has resolved pretty quickly within a month from filing. And I think it will impact all of the other cases filing, because you have parenting stuff filing in England. You have parenting stuff filed with The Hague. You have parenting stuff filed with New York. I think this is important, but I think it can be confusing if you just see the headlines. The court did, though, make it worse. So here's what the court had to file, and this was filed October 13th. This is why you've got to read. Legalese is hard. Agreed order vacating order of voluntary dismissal. This cause having come before the court, and the court being advised that an agreement has been reached between the counsel and parties, this court otherwise fully apprised in the premises the court finds. The order of voluntary dismissal entered by the court on October 13th was an inadvertent clerical error and was mistakenly entered. This was all done on the same day. The order of voluntary dismissal entered on October 13th is hereby vacated and shall be treated as though it was never entered. The case shall be treated as though it was never dismissed. The court accidentally entered a full dismissal, but it's very clear that the filing intended that only the parenting be resolved, which is why you have to look at all of the documents together to get a full picture. The relief and claims sought regarding to parenting contained in the petition for dissolution are hereby dismissed in conformity with the notice, filed October 11th. All other claims remain pending before the court. So again, the court was like, our bad. We also dismissed the whole thing. But if you look at Joe Jonas's attorney's notice of dismissal, it's clear that their intent was always to just voluntarily dismiss the parenting concerns, the custody issues. And then when we finally look at the agreed order of abatement, we see that the parties are continuing to pursue amicable resolution, which means they're continuing to be in mediation. They've engaged in mediation and intend to engage in further mediation in the hope they can reach an agreement on all issues without further involvement of the court. In order to facilitate the continued mediation, the parties agreed to abate the proceedings. They're pausing the proceedings. Abate the proceedings before the court until January 31st, 2024. So, pause. Time out. Motion to stay, Your Honor. So they are abating the case, hoping that this divorce will be resolved in mediation before January 31st, 2024. And at that time, either party may terminate or reactivate the case. So this case is on the way to being done, but is not done yet. So legalese is hard. The headlines are wrong. The parenting part is dismissed. The divorce is still ongoing. They are mediating, and this divorce will possibly be finalized. And I think financially, they probably would both want it to be finalized by the end of the year. It's October. So could they get this finalized by December? Yeah, they probably could if they're working well together. It seemed like they also were able to resolve the custody amicably and quickly, and that normally is the sticking point. So I'm optimistic that this will resolve pretty quickly. So with that, we have one more quick bit before we dive into the rest of it. Food Daily says the devil works hard, but Taylor Swift works harder. Taylor Swift showed up, took to Sophie Turner to dinner and was like, hey, this is what we're doing. And Joe Jonas is like, I'm out. Just, can we decide this? All right. Let's talk a little bit about Natalie Holloway and Joran Van Der Sloot, shall we? So, will Joran Van Der Sloot actually tell the Holloway family what happened to Natalie Holloway or not? For a quick road so far on this case, Joran Van Der Sloot is the last person to see Natalie Holloway alive. I covered this a few months ago on the channel. If you search it, you will see that, Joran Van Der Sloot, he had been extradited back to the US on older charges of extortion for extorting Natalee Holloway's mother. The allegations in that case are that he was offered or asked for hundreds of thousands of dollars to give Natalee Holloway's family information about what happened to Natalee Holloway and where her remains were buried to give the family closure. It was found that everything he said to them was bullshit. And so that is where the extortion charges are coming from. He is said to be pleading guilty to the extortion charges today, conditioned on giving a accurate recitation of what happened to Natalee Holloway. So we saw a clip from Natalee Holloway's attorneys speaking to the Today Show, saying that the plea is conditional, and we're going to go look at that right now. This case is quite long. A lot of you may remember it. I remember this from when I was, I think in late high school, early college. Glass Onion said, didn't he kill someone else? He is in custody out of the country on another murder that occurred on the anniversary of Natalee Holloway's disappearance. So, yes. All right. That'll be fine. All right. This is from the Today Show with Natalee Holloway's family attorney.
Van Der Sloot pleaded not guilty, but according to the Holloway family attorney, the court will consider a plea deal this week with a major contingency.
It was conditioned upon Mr. Van Der Sloot revealing details of how Natalee died and how her body was disposed of.
No government officials have confirmed this information to NBC News.
The entire extortion case, and again, the audacity of extorting a grieving mother is a whole nother thing. I did a whole episode about it. I'm not going to spin on that anymore. But he lied the first time. I don't know why they think he won't lie now, but we will see what happens. That is going down in court today. I know it is federal court. There will be no video or audio, but there will be reporting out of the courtroom from Chanley Painter. I'm sure others will be there. So I will be keeping an eye on that and touch back on that in short form content, either on Quick Bits or on Instagram. Either way, I'll let you know in the app when I update what happened. I have been keeping an eye on this case since it came up, but everything that's been happening in this case has just been putting stuff over. I think he's probably been working on a plea since he was extradited. And I don't know if he wants to spend time in prison in Alabama or in the US, or if he wants to go back to spending time in, I believe it's Peru. So with all of that, if you want to check out the background of that video is on the channel, and we will see if he actually gives a factual recitation of what happens. I don't know if they are going to be able to confirm what he said. He's lied about this before. I don't know how they're going to ascertain the truth of his statements, and I don't know if they promised not to prosecute him. Thank you, Elaine, for bringing in the exact date. So I don't know what we're going to see, but I'm keeping an eye on it. Okay, with all of that, we need to talk all things Kouri Richins. That was not a short Quick Bits. That was an hour of Quick Bits. The longest Quick Bits ever. We're going to talk about Kouri Richins, and then we're going to get to Q&A. But I wanted to thank everyone who gifted memberships. So many of you gifted memberships today. Thank you so much, Lizzie H., for donating like 60 memberships plus. B2 for gifting 20 memberships. Thank you so much. It's incredibly generous. And with StreamYard, I can now pull them up when you gift memberships. So let me go and find where some of these are. We can pull them up now, which is one of the reasons I love streaming on StreamYard and love being a partner with StreamYard. Because when I said it would be really fun if we could do this, StreamYard was like, we can do that. And I'm like, really? And then they rolled it out. Dawn said JoJo and Chrisley on a reality military show. The way I'm freaking gripped by special forces. Okay, because also Tom Sandoval, also Tara Reid, also Bodie Miller, also Jack Osborne. Like, I am gripped by this show. I was cheering for Savannah Chrisley. I mean, she seems like a person with a tremendous amount of grit. JoJo Siwa's showing to have a lot of grit. My husband and I are both like, we went to go watch it. And we're like, when's the next episode? The previews for the next episode are all Tom Sandoval with a bloody nose. So everybody's just kind of waiting for him to get punched in the face, I think. So I very much have been enjoying Special Forces for sure, but Dr. B has also been enjoying Special Forces. So now it's a little bit of reality TV we enjoy together. So yes, I've been absolutely seeing that. I just love it. So I'm not caught up on the last night one. CrimeCon 2024 is in Nashville. If you're interested, I'm considering. I'll let you know what I think. I don't know. I don't know. Litmus test. Will YouTube deplatform a star? I don't know if this is going to be something someone is deplatformed over. I think something needs to happen, and we will see. Lizzie H., thank you so much for all of the gifted memberships. It's tremendously, tremendously kind, and I know so many in the group appreciate it. If you are a new member, if you've just become a member, you are welcome to go to the members tab. You'll start to see it when you refresh. And there's all the past members videos. You can go and watch those when you become a member on the channel. All right. Why can't we watch live chat and replay anymore? You should be able to. Live chat should always be in replay. If it's not, it's a glitch on that end. So let's swoop. They deplatformed Ruby Frankie. I don't know why YouTube took down Ruby Frankie's channel before the criminal allegations, but I think it was before the criminal allegations. I would need to look into why they took it down. It was after the Frankies had stopped posting on it. I need more information on that because I really want to understand, and I don't know if YouTube ever made a public comment about it. I want to understand what made that choice. I think sometimes where all platforms have problems is when they don't speak openly and transparently about the decisions that they're making. So I don't know if it was taken down via court process, if the older children asked for it to be taken down. I don't know the whole circumstance there because I don't think it's been discussed publicly, but I'm very curious about it. So you guys, 96% of you think that under the California code section we went over, that Sniperwolf's behavior of filming the front of JackFilms' home was absolutely in violation of that misdemeanor code statute. So Ruby took down the channel, but I think YouTube took it all the way down. I don't know. I'm still not clear on exactly what happened. So, I do ask the people that I know, and I generally ask, do you know, this is how I approach the people who I know. Do you know if YouTube has commented on this? And if they have, can you point me to where they've commented on it? I don't demand comment. I ask to be pointed to where comment was made and wait and see. So we'll have to see. All right. I need more information. The frustrating thing is when there isn't more information. So, we will see. All right. Speaking of families. Oh, Kouri Richins. Oh, Kouri Richins. There is so much happening in this case. So, grab a snack, buckle up. We're gonna be here for a minute. We're going to be here for a hot minute talking about Kouri Richins, and then we're going to do super chats and Q&A. Let's go. Kouri Richins, a name you might be familiar with. It's a case that we are covering out of Utah. She is accused of murdering her husband by overdosing him with fentanyl in a Moscow Mule. She was not arrested till more than a year after the death of her husband, Eric Richins. She had written a children's book about grief and had just started doing a book tour. Her detention hearing got real spicy real fast. And then she wrote the walk the dog letter that the prosecution is alleging is not really witness intimidation, but witness tampering. The prosecution has asked for a no contact order. This is all before we even get to the preliminary hearing. We are at the bail's been denied. We haven't even gotten to a preliminary hearing on the case yet to move it forward. And she's sending this walk the dog letter. The defense argued that the walk the dog letter was in an envelope marked for defense counsel. The prosecution alleged that it was found in like an LSAT study book. And that walk the dog letter has continued to spiral. So there are multiple things pending regarding this walk the dog letter. And just for memory, and because this is one of the wilder things I've ever seen in criminal cases, and I've seen a lot of letters from custody, more so in juvenile cases than adult cases. Adult cases tend to get on the phone. Juveniles write a lot more letters, but this is one of the wildest letters I've seen. Like, what in the world? What in the world is this? Page 1, walk the dog. But take vague notes so you remember. It is alleged that Kouri was holding papers up to her mother on a video call. This was not sent out of the jail. When stuff is sent out of the jail, it is monitored and read. So is this a letter telling her brother what to say? Skye is saying, Skye is the defense attorney. Skye is saying even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. It's not stupid. That's exactly what the prosecution will do. Skye's not wrong. Skye's not wrong. Skye would say that you laced his marijuana gummies with fentanyl. Skye's correct. That's exactly what the prosecution would do. However, she wants to link Eric getting drugs and pills from Mexico, so we need some kind of connection. And this letter goes on to explain that she wants her mother to tell her brother to tell the lawyer a story to make the connection. So this is the background of all of the drama that's popped off. If you want to go over the entire letter, I have a video going over the entire letter. If you want me to make the letter available, I can post it. So walk the dog generally means get your story straight. However, her interpretation of what walk the dog means could be different. But that's generally what is considered. It doesn't even matter what walk the dog means. There is so much in there that seems to specifically point at the brother needing to testify a certain way. What walk the dog means almost becomes irrelevant because she's like, he can say it in his own words, but he needs to tell my lawyer this. That is the heart of it. So the prosecution asked for a no contact order between Richins and her family. The defense asked for a motion for sanctions. The defense has now made a motion to dismiss the case based on prosecutorial misconduct. The prosecution has made a motion for the defense to turn over more information, arguing that the defense has taken things out of the jail. So I think we're going to go to the opposition for the no contact order first, the reply to the no contact order, then the prosecutorial misconduct, then the motion to compel disclosure. So, walk the dog letter. The prosecution asked for a no contact order. The defense has opposed that no contact motion. Let's go briefly to the defense's opposition and then the prosecution's reply. So, defense opposition to the walk the dog letter. All righty. This is from defense. Relief requested. The state's motion has no basis in law and fact and should be promptly denied. Not only is the motion without merit, it violates Rule 3.4 and 3.6 of the Utah Rules of Professional Conduct. Such violations serve as additional grounds for denial. The defense is very frustrated that the prosecution filed the walk the dog letter as an exhibit. They don't like that it's an exhibit. They don't like that it's public. The state's motion falsely asserts that Ms. Richins is guilty of witness tampering, a crime the state has not charged and concedes is lacking in evidence. Rather, and I want to see if the state is going to do it, rather than a good faith request for relief pursuant to Rule 11, footnote 2, the motion's apparent purpose is to guide the media's interpretation of the so-called walk the dog letter. I mean, it says walk the dog across the top. What the fuck else do we call it? It is a walk the dog letter, which the state has recklessly characterized as evidence of further witness tampering. Despite its brazen claims of criminal activity, the state's motion conspicuously fails to establish a single instance of witness tampering. The defense is pissed. The state is pissed. Everyone is pissed. The shade, though, is delightful. Even worse, the motion confirms the state does not have evidence of the crime it claims has already occurred. Instead, the state admits it is unclear whether Richins ever disclosed the walk the dog letter or its contents to her mother, Lisa Darden, or anyone else. The motion also offers no evidence that the narrative advanced in the walk the dog letter is false. Rather than support its claims with evidence, the state simply asserts that the walk the dog letters concocts a false narrative. In addition, the walk the dog letter, the state's motion references yet another letter that the defendant held up during a video conference with her mother, the September the 13th letter. However, the state admits it does not know the author or the contents of that letter, stating the letter was not found inside defendant's cell. The state asserts that there is a strong inference that the September 13th letter was destroyed or flushed, but once again, the state offers no actual support in its allegation about that letter being destroyed or flushed. This is likely because the September 13th letter was not destroyed or flushed. Defense counsel obtained the September 13th letter, which was not even authored by Richins, after the state filed its motion. In short, so the defense has it. Who wrote it? I have questions. My Crest White strips just showed up because we got to get ready for BravoCon. I don't think that Kouri got her Crest White strips. They're contraband in custody. Anna, I think the part about intimidating the sister-in-laws is appalling, but the defense is not wrong in saying, where is the evidence that this letter was shown to the mother? Prove that this letter was held up on camera and shown to anyone. If it was written but never shown to anyone, it might have been intended, but if it was never conveyed, that's different. The state's assertion that Ms. Richins has engaged in witness tampering is entirely unfounded. The motion includes improper assertions of personal knowledge and opinion regarding facts at issue and comments regarding the credibility of witnesses. For example, the state characterizes the letter as followed. This letter claims that defense counsel wants to link Eric Richins getting drugs and pills from Mexico to the fentanyl that caused his death. No such link exists. Therefore, the defendant concocted a false narrative. By declaring that no such link exists and that Ms. Richins has concocted a false narrative, the state's motion improperly comments on the veracity of Richins' statements, her credibility, and the credibility of any witnesses that may be called to testify on her behalf. Among other things, the state's assertions constitute a clear violation of Rule 3.4, which states a lawyer shall not assert personal knowledge of facts in issue except when testifying as a witness, or state a personal opinion as to the credibility of a witness or the guilt of the innocence of an accused. They're saying that defendant concocts a false narrative because no link exists. The prosecution has the evidence that they believe is the case, so I can understand why the prosecution is saying there is no link. We've investigated this case. I think it's a bit of a reach, but I'm also a former prosecutor, so you guys let me know what you think. Do you think that that's a reach, that lawyer is asserting a personal opinion, or are they stating facts based on the evidence that they've investigated? But this defense attorney's pissed, so I get why she's arguing it. Further, the Utah Supreme Court has held that a prosecutor engages in misconduct when he or she asserts personal knowledge of facts in issue or expresses personal opinion. I think stating no such link exists goes to the investigation versus the I know that they're lying. Like there's personal knowledge goes to something outside of the investigation, or at least that's how I interpret it. The personal opinion of a prosecutor is a form of unsworn, unchecked testimony, which tends to exploit the influence of the prosecutor's office and undermine the objective detachment that should separate a lawyer from the cause being argued. That generally applies to like closing arguments in trial. A prosecutor can't get into trial and be like, ladies and gentlemen of the jury, you heard witness A, B, and C, and I absolutely believe them. I know them. I know that they're telling you the truth. You can't vouch for someone like that. You can't vouch for testimony like that. You can't extend a personal opinion like that. You can argue the evidence is totally contrary to what that defendant said. So who's lying? But you can't say, I know they're lying. I looked in their eyes. Liar! That doesn't work. The chat's like, sounds like Elaine's closing. Yeah, that on a level of what not to do. Though in civil law, it's a little different than what this defense attorney is pointing out for the prosecution. For the prosecution, it goes kind of above and beyond that because of the weight that the office carries being an arm of the state, right? Ironically, it's the state's motion, not Ms. Richins, that concocts a false narrative. Oh! So, chat, as always, you are flawless and fast. Y'all are lovely and the best. Fast. Y'all are fast. So is the defense arguing that what's in the letter is true? And here's what I struggle with. Kouri Richins has said that the letter is part of a novel that she's writing, right? So if it's a fictional account, why is the lawyer arguing in the motion that it's true? Their stories are not together. The lawyer's like, please the fuck let me do my job. And Kouri Richins is like, it's a story. And the lawyer's like, but it's true. Those two things are not congruent. It's the state's motion, not Ms. Richins, that concocts a false narrative. Though Ms. Richins says it's a novel, Ms. Richins has muddied up her own defense with her own statements. I think Ms. Richins was trying to fix it. Let your lawyer lawyer. Just let your lawyers lawyer. Just let your lawyers lawyer. You are not smarter than they are. You're never going to be able to see a case better than your lawyer. Your lawyer knows how to lawyer. Tell them the things and trust that they will do what is best for you with that information. When you try to fix it, it is much more likely that you are going to fuck it up and fuck yourself. But at the end of the day, the person who is facing life in prison is not Sky, it's Kouri. So I understand why Kouri might think that she can just fix it all, but you can't. You can't fix it. You might have made it worse. Anna said, the Fifth Amendment is your friend. Yes, the Fifth Amendment only works if you use it, right? You have to actually shut the fuck up for it to be helpful to you, which I empathize with. It has to be hard. Trusting your lawyers to lawyer has got to be tremendously difficult. There are times I do not trust Dr. B to load the dishwasher the right way because there is, in fact, a right way and a wrong way. I understand how hard it must be to trust your life in someone else's hands. But this is what they're trained for. The 3D chess game is what lawyers enjoy. And it's so deeply consequential. But if you box your attorney in by making all kinds of statements that can be used against you, you've made it so hard for them to do their job. And Sky seems like a very good lawyer. Let your lawyer do their job. Helping never helps. The motion should also be denied on grounds that it violates 3.4 of the Utah Rules of Civil Procedure and the gag order entered by this court, footnote 3. See defendant's reply in support of motion for sanctions. All right. Kathy Adaz said Kouri and Sarah Boone are their own worst enemies. There are certain personalities that cannot let it go. And I get that. I get that. Christine said loading the dishwasher is indeed 3D chess. Yes. We just have After 20 years of marriage, still varying opinions on how to do that. Which makes it interesting when teaching our kids. I'm like, no, we do it this way. And Dr. B's like, no, we do it this way. No. So that was the defense's opposition to the motion for no contact order based on the walk the dog letter that they take tremendous issue with. The prosecution responded with a reply in support of the motion for no contact order. So let's go to the prosecution's reply to that. I'm trying to keep the motions grouped together. All right. Can you guys see? Yay. Trust me, chat. The way I'm going to try to figure out how to do like fruit matching games on my Switch after this, after watching Ludwig's stream last night, is next. There are days when I'm like, it would be fun to game on stream. And then there are days I'm like, but I also need to do this. This is the prosecution's reply memorandum in support of motion for no contact order. Walk the dog letter speaks for itself. Quote, Sky has to make the connection between Eric Richins and Mexico because that's what makes the most sense in her mind. She's the lawyer. Tell Ronnie, brother, don't overanalyze it. It was a quick 2-minute conversation. Lol. Tell him I need him to do this. Bring me home and then we will get those damn bitches. And by bitches, she does not mean the walk the dog type. She means her sisters-in-law, which becomes clear also in the letter. She says they were always jealous of her. I can't imagine how painful this would be for the decedent's family when this letter came out, but she absolutely says, we will get those damn bitches. As a very loud, rumbly military-style helicopter. As a prosecutor, I would use this letter in everything that I could use this letter in. This letter is just like gold raining down from the heavens of prosecutorial gifts from the sky, right? It is just wild. The prosecution goes on to say, a no contact order is necessary and appropriate. The walk the dog letter is not an attorney-client communication, nor is it a fictional story about a Mexican prison. Footnote 1. It is the defendant's instruction to her mother to induce her brother to testify falsely. It is clear from the content and context of the letter that it is the concoction of a phony narrative. It is also contrary to the defendant's many prior statements that Eric Richins did not use illicit drugs. Footnotes 1 and 2. Just cite to where those things are said. New matters raised in the opposition, which you're not allowed to do. In opposing the state's motion for a no contact order, the defense accuses the officers of this court of violating the rules of professional conduct. Don't worry. You pointing out that it's a new matter means the defense is just going to bring a motion for prosecutorial misconduct. They'll get there in a few days. Alleges prosecutorial misconduct. They bring a whole nother motion. Discloses that it obtained a copy of letter number 2 from inside the jail. None of this makes a persuasive case to not issue a no contact order. It is deflection. The sass that these lawyers have. This will be an interesting trial if this goes to trial. But that walk the dog letter is going to make it real hard. The prosecution, the defense, and this court each share the obligation to protect the integrity of this proceeding. The defendant's walk the dog letter is plain, freestanding evidence of witness tampering, and it establishes the defendant's plan and intent to present false evidence. The defendant instructs her brother to testify to fit, quote, what makes the most sense to defense counsel. Here's what it does to defense counsel. We're going to sidebar for a second. It puts defense counsel in a place where even if this is the defense that they wanted to make, that Eric Richins accidentally overdosed, that he was procuring narcotics for himself, if that's the defense they wanted to go with, which is a defense that makes sense when it took over a year for her to be prosecuted, when there really isn't any way to argue it. Though, again, from everything I've read in this case, this scene when paramedics arrive does not read as an OD scene. There aren't other drugs on scene anywhere. Generally, when people OD, they do not clean up the evidence of the narcotics around them that they had been using, things like that. This doesn't read like an OD scene, but of course things can happen. Anything is possible. Reality is strange. But the defense doesn't have many options to go when these are the only two adults in the house, and it's agreed that he was overdosed on fentanyl and that he had so many times a lethal dose in his system. And then you have witnesses saying that she was procuring narcotics from them. So there's not a lot for the defense to work with here. And this was one of the things the defense was trying to work with. And now, if the defense tries to work that line of defense, this letter is going to come up and just be like, hey, hi, is this the story we concocted while in custody? This letter is going to just completely cut off that line of defense, which if I were the defense attorney, I'd be fucking pissed about. I saw a question in the chat. What does EDB's sweatshirt say? I don't think I've talked about what my sweatshirt says. This sweatshirt was a gift, and it says, nobody likes a douche canoe. Yep, that's what my sweatshirt says today. So there we go. That is what the sweatshirt says. It's true. It's true. All right, let us continue with this letter. The prosecution's coming back spicy. The defense went out spicy. The prosecution's coming back spicy. Everybody's spicy. The defendant's walk the dog letter is plain freestanding evidence of witness tampering. And establishes the defendant's plan to an intent to present false evidence. The defendant instructs her brother to testify to fit what makes the most sense to defense counsel. Excuse me. Indeed, she wants brother Ronald Darden to lie to defense counsel. This should concern us all. Chad, are you concerned? I'm concerned. Upon learning about the letter, the state immediately sought a narrowly tailored no contact order to prevent more tampering like this from taking place. It would have been irresponsible of the state to proceed otherwise. The defense should share this concern and commit to an honest presentation of the evidence. Snappy. 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 They're like, excuse me, counsel, are you not concerned that your client is trying to use you to, suborn perjury through her brother? Does that not concern you? Are you not concerned? Instead, in the memorandum in opposition and its predecessor, the motion to enforce order and for contempt sanctions, levels ad hominem allegations of misconduct towards defense counsel's colleagues in the bar. That's a long-winded way of saying it, but yes, there are ad hominem attacks in there. This is very unfortunate. This is very unfortunate. It's giving, I'm not mad, I'm just really disappointed. This is very unfortunate. Far from acknowledging the need to protect the case from lies and tampering, the opposition neither recognizes these concerns nor suggests any other possible less restrictive means to prevent false testimony. The prosecution did not create the circumstance with the walk the dog letter. The defendant did that. The prosecution's like, your client said what the fuck she said. What is needed now is a universal commitment to proceed without unlawful tampering. This proceeding is public. Oh, the prosecution. Lyndon, yes. From the last motion, this level of hyperbole is unhelpful. Me to the internet most time. Some days I am. Defense filings in the wake of the motion seem more concerned with what is in the public domain than with what has happened and what may yet happen to impact the integrity of this case. This is a misplaced concern. It does not matter what members of the public in London or New York think about the defendant. On YouTube, we're on YouTube. We have thoughts. Without a doubt, an unbiased, fair, and impartial jury will ultimately be seated in this case. It matters that the jury receive truthful, untainted evidence. This proceeding, like all criminal proceedings, is public. The Utah Supreme Court has held that public and press have a right to access criminal proceedings under the First Amendment, the Utah Constitution, and common law. We talk more about that in Utah tomorrow because part of the 8 passengers case has been sealed. In addition to objecting to the motion for gag order, footnote voice, I forgot. In addition to objecting to the motion for gag order, the defense has embraced all the pretrial publicity in this case, providing photographs and information to news programs and arranging interviews and interview content. Sky is having my girls do the first interview with Good Morning America. Parties courting publicity should not be heard to complain about it. Ooh. Ooh. Parties courting publicity should not be heard to complain about it.
The spicy professionalness of these lawyers, I'm living for. This is a sad and serious case.
This is a sad and serious case.
However, the sass of these lawyers on both sides, I am living for. I am living for it. I love it so much.
I love it so much. The prosecution is like, you want to come for me? Okay, Miss Good Morning America, let me come for you. Snappy. The state filed the walk the dog letter as an exhibit in the record because it was required to, not because it wanted to guide the media's interpretation. Look, the walk the dog letter is fucking epic. Hence, the memorandum opposition's accusation that the state filed the letter in bad faith is refuted by well-established constitutional and common law jurisprudence. Footnote 4. It may be presumed that the reader is capable of interpreting the walk the dog letter without any guidance from the state. Yeah. We did polls in the chat on how you guys interpreted the letter. The public is able to interpret the letter on their own. Let's see. The motion argues that the walk the dog letter is evidence of the defendant's witness tampering, and that a no contact order is necessary to limit the defendant's ability to, quote, further engage in witness tampering going further. The opposition accuses the state of mischaracterizing the walk the dog letter as further witness tampering. The motion never did that. The quote is not in the motion. The opposition misreads and misquotes the motion use of the word further. Oh, now we're getting a reading lesson. Gosh, I love a reading lesson. Any objective reading and accurate quote of the motion confirms that the motion uses the word further prospectively, not in reference to the walk the dog letter. Accordingly, the opposition's accusation that the state has acted recklessly in mischaracterizing the letter is belied by an honest reading of the motion. This level of hyperbole is not helpful. Saying that further witness tampering means not that the walk the dog letter is further tampering, but that anything that comes next is further witness tampering. Lori Leanne said, Runkle and Danny Ann both said that they would fire Kouri after this letter. Oh, I'm sure a lot of defense attorneys would do. Where is Rottenborn for this reading lesson? Did I continue to read this correctly? Correctly? Robin, the ADR Pro, said, I love the lawyer sass. It is an art I use a lot. It is so good. It is so good. It is so well done. It really just, it just, both sides have their levels of fire, and I appreciate it. Footnote 5, after honest reading of the motion, even so, the walk the dog letter may intend Emily, it's not sassy if you don't read it right. I have not continued to read it correctly. Even so, the walk the dog letter may indeed be the first time the defendant may... Again! Damn it, I need a do-over. Even so, the walk the dog letter may indeed not be the first time the defendant witness tampered. Undersigned counsel represents as an officer of the court that the defendant is also under investigation for witness tampering. The date on that court filing was June 11th, 2023. So defendant is under investigation for witness tampering. Undersigned counsel have always acted ethically and professionally. The motion accurately informed the court that the state's investigation has found no evidence that Eric Richins obtained drugs from Mexico or that any such drugs caused his death. Footnote 6. In fact, on multiple occasions, the defendant has vehemently asserted that Eric Richins did not use drugs except for the occasional THC gummy. Each of these statements has been produced in discovery to the defense. Ma'am, we're simply reiterating what your client has said over and over and over to law enforcement. It says Eternal Valentine Days. It says did not use drugs except for the occasional THC gummy. And, you know, I think in Utah that would still qualify as drugs. I'm guessing. Other places, not so much. So substance, yes. Drugs, no, maybe. That was footnote 6. Let's see. Where did footnote 6 come from? Presenting investigative results and arguing them is what lawyers do every single day. Emily, keep reading. Rule 3.4e addresses the distinct and separate behavior of lawyers asserting first-hand knowledge and personal opinion. That did not happen here. Accordingly, the opposition's accusation that the state improperly asserted knowledge of facts in issue or personal opinion is disproved by the customary reading and application of Rule 3.4e, footnote 7. The defense knows that whether someone violates Rule 3.4 is an issue for the Utah State Bar and not this court. Nevertheless, the defense deliberately leveled a Rule 3.4 accusation here to deflect from the real problem. That's personal opinion. That's like your opinion. Your Honor, they're deflecting. Can we focus on the letter? The opposition incorporates by reference other filings, additional accusations against the state involving Utah Rule of Professional Conduct 3.6 and Rule of Civil Procedure 11 and the protective order. Likewise, the state incorporates by reference its responses that proves these accusations false, just like all the defense others' accusations against the state. That reads as like, me. Just like all the other accusations, Your Honor. Throughout the memorandum, the defense misinterprets straightforward facts and well-known law in a panicked effort to manufacture accusations against officers of this court, members of the bar in good standing. The state looks forward to the day when the defense finish that statement, Chad. The state looks forward to the day when the defense realizes their client's audacity, acknowledges their client's audacity, decides that they will not be a party to perjury, litigates by addressing the merits of an issue instead of asserting false, frivolous, ad hominem accusations. The opposition ignored and thus presumably concedes the motion's two substantive arguments. The opposition does not present any evidence or argument that the letter is anything other than what it appears to be, a letter that the defendant wrote to her mother, directing her mother to instruct her brother to testify falsely. Yeah, that's how it reads to me. The fact that letter number 2, not an attorney-client communication, footnote 8, was carried out of the Summit County Jail confirms that the defendant has circumvented inmate mail policies. Additionally, the memorandum opposition does not present any evidence or argument that the requested no conduct order is anything other than an appropriate precaution to protect the integrity of the proceeding going forward. Footnote 8. Letter number 2 was not even authored by Miss Richins. So they're taking things out of the jail, which is not going to go over well. We're going to get there in a minute. The defendant should not be permitted to have contact with her mother or her brother to prevent further tampering with testimony. The state respectfully requests that the court grant the state's motion for no contact order. The state has not ruled on this yet, but the litigation over it is not done. Where we are going next is to the prosecution motion to compel good cause disclosures. This relates to the defense taking things out of custody, which is not going to go over well with the state. So this is and then we'll get to the motion for prosecutorial misconduct. So the motion to compel good cause disclosures is the prosecution asking the court to make the defense do something. So let us get to that now. Statement of relief sought and grounds. The state moves, pursuant to Utah Criminal Code 16b1 and Rule of Civil Procedure 37, to compel the defense to produce to the prosecution approximately 60 handwritten pages of paper referred to by the defendant as a fictional manuscript. This document, handwritten by the defendant, was carried out of the Summit County Jail by defense counsel in violation of jail policy during the state's aggravated murder prosecution and its witness tampering investigation. The defendant has stated that the walk the dog letter is part of this fictional manuscript. The defendant described the walk the dog letter as part of like a 65-page freaking mystery novel I've been working on.
Half the story is true, but there's a lot of parts that aren't.
The state also seeks to compel the production of additional relevant, non-privileged material, if any, that the defense counsel improperly removed from the jail on or about September 14th. This evidence is material and essential to the state's witness tampering investigation and preparation for trial. The state has met in conferring good faith with defense counsel to resolve this dispute without court action. Ultimately, the defense counsel was disinclined to acquiesce to the state's request. I'm sorry, it says refused to produce this material subject to a privilege review. I think it should be privilege reviewed, but it should be turned over. The motion is proportional under Utah Rule of Civil Procedure 26. Factual background. What did the defense do? On September 14th, 2023, Summit County Sheriff's deputies seized a document written in the form of a letter with the phrase walk the dog handwritten on the top margin. The walk the dog letter was found in a law school admission test preparatory book inside the defendant's jail cell. The letter includes defendant's instruction to her mother to induce her brother to testify falsely. Later the same day, defense counsel visited the defendant at the jail. According to defense counsel, the document passed her an envelope labeled Sky Lazaro, attorney privileged, trusting defense counsel and on the basis of her firm's solid reputation in the legal community, Summit County Sheriff's deputies did not search defense counsel or inspect the envelope for non-privileged material when defense counsel departed the jail. It is now known, because the defense attorney said it in their motion, it is now known both on the basis of defense counsel's admission and the defendant's statements and recorded jail calls that the envelope contained more than 60 pages of defendant's non-privileged fictional manuscript. The defendant claims the manuscript is a nonfiction telling of the offense of her homicide case up until her detention hearing. At that point, the fictional manuscript allegedly transitions to a fictional story involving bail jumping, fleeing to Mexico, and incarceration in a Mexican prison. Footnote 1. A photograph of the envelope taken on or about September 15th indicates that the envelope contains at least 60 pages of material. Based on defense counsel's statement, the envelope also contained a non-privileged letter to defendant from another inmate. Footnote 2. On information and belief, this is letter number 2 identified in the prior memorandum held up on the video camera for defendant's mother to read. It's a violation of jail policy for one inmate to write correspondence to another inmate. This is a problem. It is unclear what, if any, triggered additional non-privileged material may also have been inside the envelope. On September 16th, during a call with her mother, Lisa Darden, the defendant explained that the walk the dog letter is an excerpt of
this whole freaking story that is like 65 pages long.
On September 19th, 2023, in a call with her brother, Ronald Darden, the defendant expands on the walk the dog letter and fictional manuscript, saying,
it's this really long, like 60-something page book. Like they literally took the walk the dog letter out of the story. It's a 65-page novel. Some of it's true, some of it's not. I gave it to Sky. Like, I totally gave it to her and asked her if she would, like, sneak me in nail polish. Wait. No, that's not what it says. Keep going. I gave it to her. It was, like, in my Sky folder. Sky has the freaking book. Get a book deal.
During this call, the defendant emphasizes that, oh, God damn it.
On the front of the book, it literally says, these are true events that have happened in my life. But the statements, the events, or this is surrounding, it says something like that. I don't know. These are surrounding the events of my life. But the statements, the book, and the way it plays out have been falsified for a fictional novel. It's called To Hell and Back. None of this can be used against me. This is only a book.
Babes, you said it was true. You said it was true. On October 2nd, 2023, at the state's invitation, the parties met and conferred in good faith about the envelope and its content. Defense counsel admitted to carrying the envelope and its contents, including non-privileged content, out of the Summit County Jail. Defense counsel explained that she felt that she had done nothing improper because sheriff's deputies chose not to inspect the envelope. The sheriffs aren't going to appreciate that at all. And I imagine it's going to change this attorney's relationship with the sheriffs when she comes in and out of the jail if she's taking things out of the jail that she knows she's not supposed to take. Defense counsel did not explain why in the subsequent 18 days she failed to disclose the existence of non-privileged fictional manuscript to the state and only disclosed its existence when confronted by the state. Footnote 3. The defense disclosed the existence of the letter written by another inmate in opposition to motion for no contact order filed on September 28th, 2023. Nevertheless, it withheld disclosing the existence of the fictional manuscript in this filing, even though it's material and relevant. The state is mindful that carrying the fictional manuscript away from the jail and not disclosing it under the circumstances presented here could lead to the appearance of evidence tampering and obstruction of justice. The way these counts, they're going to be like prosecutorial misconduct, and they're going to be like obstruction. Obstruction. Oh boy. During the meet and confer, the state requested that the defense produce all non-privileged material contained in the envelope. The parties came to an agreement that the defense would provide the envelope and its content to AT. AT is an attorney selected by the defense and already retained by the prosecution to review and redact certain discovery materials, such as defendant's electronics, for attorney-client privilege. The taint attorney. It's been a while since we've had a taint attorney, but there is indeed. We have come to the part of this ridiculous wild ride where we now also have a taint attorney. The parties further agreed that if the taint attorney determined the 60-page fictional manuscript was not privileged, the defense would provide it to the state. On October 6, 2023, despite the agreement reached during the meet and confer, defense counsel wrote an email to the state. I am having concern about producing the contents of the packet because of the transmission of it to me and that it contains privileged documents. It is my position that it is all privileged. No. If the taint attorney says it's not, then it's not, and you got to turn it over. You have to obey the taint attorney. That's what they said. That's what she said. Because of the transmission of it to me, and it contains privileged documents, it is my position that it is all privileged. We can discuss further, but I believe it would be a violation of attorney-client privilege to willfully turn it over. That reads to me like, go get a court order. Go get a court order. Go get a court order. If you want me to turn over what my client gave to me, go get a court order. At least there's already a taint attorney. Yes, this is real life, Tracy. That is a real thing. The taint attorney is making sure that that information is not tainted with privilege, or that privilege information does not get tainted and turned over. So it is the taint attorney. Sometimes it's to determine whether or not certain evidence has been tainted by illegally gotten evidence and stuff like that. So it is a colloquial term. I don't know why they just don't call it the privilege attorney, like the gatekeeper attorney. No. It is the taint attorney. Look, it has been a heavily male dominated field. They all thought it was fine. Everybody's like, we all know what it means. It's fine. It's a taint attorney. On October 10th, 8 days after the meet and confer, the defense had yet to provide the envelope and its contents to the taint attorney. Accordingly, the state reminded the defense of their agreement to do so. In response, defense counsel wrote an email to the state saying, I have counseled with our general counsel on the matter, and unfortunately, from an ethical standpoint and my duties to my client, my hands are tied, and now refuses to provide the envelope and its content to the taint attorney. This motion follows. It could be a privilege attorney. I think so, but they want to call it the taint attorney. So taint is what's happening. Don't get it wrong. It's taint right. There are so many better titles. Taint is what they're doing. Ashley, so what do you do for a living? I'm a taint attorney. Well, yes, we have to make sure the taint is cleared. Oh, summer love. No, we're not going to stop saying taint. It's going to happen a lot. It's going to happen a lot throughout this. Sarah, you are having way too much fun saying that word.
I mean, maybe a little bit. Taint. Taint.
Maybe a little. We look for the laughs where we can find them. This whole scenario is so fucking ridiculous. The walk the dog letter was ridiculous. Everything that has happened afterwards is absolutely wild to me. The fact that there's like now a manuscript that's like 65 pages long, and that the attorney is like, sure, I'll turn it over. No, I won't turn it over. It's going to be bad for Kouri Richins. I understand why Sky is like, I need the court to make me turn this over. Like, I understand that Sky is trying to protect herself as an attorney, and the prosecution is like, you said you would turn it over. And the defense is like, you just have to get a court order. You just have to get a court order. She could have said that at the beginning and maybe hadn't read all 65 pages going, oh, fucking hell. But I think the court's going to order it to go to the taint attorney to see if anything's privileged in it. But if it's a manuscript, it's not going to be privileged. And if they have multiple recordings of the defendant saying this is a fictional account, there's nothing in there that's going to be privileged. So a privilege can't really be asserted to it, even though it was handed by the client to the lawyer. Legal argument and authority. The defense must disclose to the prosecutor any item of evidence which the court determines on good cause should be made available to the prosecutor in order for the prosecutor to adequately prepare for the prosecutor's case for trial. Generally, trial courts are allowed broad discretion in granting or denying discovery requests. Good cause exists for the court to order the defense to produce the prosecution approximately 60 pages of the defendant's fictional manuscript. The value of the walk the dog letter in preparing the prosecution's case for trial and investigating witness tampering in this case is self-evident. Yeah, you done fucked up, Kouri. What in the world is that letter? The prosecution is like, the prosecution's sitting here going, there's 60 more pages, there's 60 more pages, there's 60 more pages. She wrote 60 more. You guys, she wrote 60 more pages. She wrote 60 more pages. What is life? That is what the prosecutors are doing. The walk the dog letter is this defendant's frantic, dishonest attempt to explain how Eric Richins, the victim, may have obtained illicit drugs when all available evidence establishes that she, in fact, obtained the fatal fentanyl. The walk the dog letter illustrates the defendant's consciousness of guilt. There is every reason to believe that the remaining 60 pages of the fictional manuscript are as equally valuable as the walk the dog letter. The prosecutors are like, there is 60 more pages of her nonsense. The defendant's admission that some of the fictional manuscript is true affirms that it is necessary for adequate preparation of the prosecution's case for trial. Consciousness of guilt is the beginning of how this becomes relevant. The fictional manuscript is not privileged because it was not, by the defendant's own admission, prepared for her counsel for the purpose of securing legal advice. Footnote 5. Oh, shit. Perhaps the defendant wrote the fictional manuscript to publish for profit, like her ghost-written book. Are you with me? First of all, the shade at the ghostwriter. I don't think it's meant to be ghostwriter shade, but it is kind of shady and funny. But also the dig at maybe she wants it to be published like her other book about the death of her husband. who she's accused of killing. Oh, the shade. The shade. Defense counsel's caginess and reversals on this issue do nothing to quiet this belief. The fictional manuscript is not privileged because it was not, by the defendant's own admission, prepared for her counsel for the purpose of securing legal advice. The defendant repeatedly and adamantly refers to the fictional manuscript as a book, a freaking book, a fictional mystery book, a novel, a mystery novel, a fictional novel. Although unnecessary, the state understands that it may be prudent for the court or the taint attorney to conduct a privilege review of the fictional manuscript. The state requests any such review be expedited because the resulting production may pertain to the motion hearing scheduled for November 3rd. Defense counsel's statement, as well as the defendant's course of conduct, indicate that the envelope contains additional non-privileged material that will help the state adequately prepare for trial, including a letter written by another inmate. Defense counsel's unwillingness to disclose the general subject matter of the envelope's broader content only amplifies this indication. Accordingly, the state requests that the court or the taint attorney review the full content of the envelope to determine what non-privileged material it contains that must be provided to the state. The court respectfully requests that the state requests that the court grant the motion. Okay, the part I've been waiting for. We're going to go through the transcript with her father. Are you ready? Are you ready? Are you ready for it? Let's do that. All right. This is an entire telephone transcript. We are going through all of it. Ready? All right. Let's do it. Official transcript of electronic recording. Well, let me do this. Let me make this a little bit bigger. This is from September 19th. This is between Kouri Richins and Rooney Darden, I believe her dad. Mr. Rooney. Hey, Kouri. Hi, what are you doing? So working. So what? You can call but not text? Kouri, I guess so. I don't know. There has to be some kind of mix up because the guy that did like my disciplinary action yesterday, he never said that I couldn't text, like message. He said I had to video call. So, but then, oh yeah, maybe. The deputies here are saying, no, he needs, okay, so this is what the sentence says. Limit phone calls. It says limit phone calls to voice only and only handwritten letters out 90 days. For what? Exactly. What does that mean? No, she got in trouble. Doesn't it like Kouri Richins only? You literally did not do anything. Like, what the hell are they disciplining you for, Kouri? And then I'm on like 30 days of lockdown, 23 hours a day, no commissary. Ugh. For what? Like, they have to give you a reason, Richins, for the paperwork. That's what they're saying. For my paperwork that they illegally found, which I wasn't hiding it, but you know, it was in a book. You were absolutely hiding it. All right, whatever. For your paper, what does that have to do with the jail? What does that have to do with your behavior in the jail? It's violating jail rules. There are rules, people. Jail has a fuck ton of them. You get in trouble for shit that you would consider stupid because jail. Richins, well, I guess the jail gets to do disciplinary actions too. It's like they're saying the jail does disciplinary. Again, for what? And the court, and they're like trying to say like my paperwork was contraband. Some of it is. Contraband, yeah. Like you snuck it in there? What the hell does that mean, Kouri? Well, it doesn't make, they just tried to stack stacks. We have stacks. Bingo! Who had bingo today? We have stacks, we have contraband, we have taint attorneys, we have letters. Bingo, bingo. They just tried to stack as many things on there as they could. Like there's 3 different, they called them findings, and they're all, I mean, that's what the jail does. Contraband means any item that's relating is illegal to be possessed or sold. Kouri, yeah. Like what the fuck are you talking about? Is this her brother? Kouri, I know. It doesn't make any freaking, hold on a sec. Oh, I don't know what she said. Anyway, I have no idea how one freaking relates to the other. It doesn't. Those fucking piece of shit Park City police told the jail what to do. Kouri, yeah. That's what fucking happened. Kouri, that's what it comes down to. Well, they just keep saying it's a letter. It was never a letter. Like, it was part of a freaking book. Like, it's never a letter. It was never in an envelope, or it's not about the pasta. 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 I'm sorry for the half of you that are really confused by my pasta outburst. The other half will explain. The other half of the chat will explain. Like, it was never a letter. It was never in an envelope. It was part of the book you're writing? Kouri, yeah. So I was writing this book so basically it's like everything that happened until like the detention hearing, and yeah. Then at the detention hearing, I actually get out of jail. So it's like a fiction mystery kind of book, Uh-huh. So anyways, at the detention hearing, I actually get out and I'm on this mission to go to Mexico to like find these pills. And I'm like, call dad up and I'm like, Dad, you've got to come with me to do this. I guess she's talking to brother. Like, it's this whole fictional mystery book. And so like, obviously it's not real. Like, when my dad has been dead for 2 years. Like, I didn't know that. Well, there's some new information. There's some new information in that sense. I guess she's talking to her brother. The brother who she was trying to have walk the dog. Yeah. So me. Facts. So me. So me and dad go to Mexico. I mean, it's like this really long, like 60-page book. The books I'm reading are definitely not 60 pages long. It's this really long, like 60-page something book. And oh shit, yeah. Me and dad go to Mexico and we go to the ranch that Eric stayed at. And then we find out there's human trafficking. And then dad is trying to like find out like who sold it to him. And then I was like the guy in the kitchen. And then we're like, oh my gosh, we got it. And we recorded it. Like, Ronnie, this is how ridiculous this thing is. I'm not kidding. So then dad's like, oh, it's the guy from the kitchen. And I'm like, yeah, he just sold me some stuff. And I was like, oh my God, there's human trafficking here. We gotta go. Anyway, so we go back to cross the border. I get arrested because I was out on bail and not supposed to leave the state. And I write to you and mom like this letter from Mexico, the Mexican prison. And I'm like, get me out. Like, you got to come get me. Like, all this stuff, like, you got to tell them. And like, I can't believe this is happening. And then I get out of Mexico jail and then the trial starts. And like, I write a book about the trial. Who's testifying? Like, they literally took those papers out of my story. Oh my God, are you serious? Yes, that's what I'm trying to say. It's like a 65-page novel. They read the whole thing. And the front of the novel, this is the worst part. On the front of the book, it literally says, these are true events. These are stories ripped from the headlines. These are true events that have happened in my life. But the statements, like the events or like this is surrounding, it says something like, these are statements of events of my life. Like sands through the hourglass. These are the days of our lives. But the statements, the events, and the way that it plays out have been like falsified for a fictional novel. It's caused to hell and back. None of this can be used against me. This is only a book. Babes, wishful thinking. Like, I love that you're trying to manifest that here for you, but that's not going to happen. Like this manifestation of none of this can be used against me is not happening. Is not happening at all. It's not going to happen. You can't make fetch happen, Kouri. So they read the whole. Are you fucking serious? Yes, that is why this is so crazy. So I put an extra so in there. That is why this is crazy. They read the whole book, but only took out 3 pages that they sent to them. There is no way the jail guards read 65 pages of whatever the fuck this is and then grabbed the walk the dog letter. What is happening? They're not standing there reading 65 pages of whatever the fuck you're talking about and then giving it back to you. If they're taking the novel, they're taking all of it. They're not just taking 3 pages of it. Your lawyer wouldn't have had it. If they had seen the rest of it, they would have taken it. Yeah, that is why this is crazy. So they read the whole book, but only took out 3 pages and they sent it to them, knowing that's what it said on the front of it, knowing that I'm talking about going to Mexico with my dad that's passed away. Like, what? I have some more questions about that because, yeah, it definitely does not read that way, like, at all, obviously, because they pick and choose. They pick and choose. And it even talks about, like, I said something about, I want Sky to get me some white strips or something, like, ... And then the thing is, so, like, I get locked down because I got, like, white strips in. And, like, I put, like, I don't know, some girl told me on me or something. Wait, she did get the white strips. That's the breaking news in all of this. How the fuck does she get the white strips? Who smuggled white strips into her? Of course, somebody told on you, Kouri. I imagine that some of the other women in custody find you insufferable. White strips. You got the white strips. Congratulations on your contraband. I'm sure that's already been found. Some girl told on me or something. Like I write this whole thing and then it talks about like the media stuff and like, oh my gosh, now I'm in Mexico prison. Like the media is going to go crazy. Like, so like some of it's like, so a lot of it, like the first 6 chapters are like true what, like everything's that's played out, you know? And then what words happened? That's a lot of lines. What words just happened? What words just happened? This is hurting my brain. Like I write this whole thing and then it talks about like the media stuff. And then I'm like, oh my gosh, now I'm in Mexico prison. Like the media is going to go crazy. Like, so like some of it's like, so a lot of like the first 6 chapters are like true what, like everything that's played out, you know? No, I don't fucking know. I don't know. I don't fucking know. And then, yeah, the last of it is kind of all altered. And like I said, like some of it's true and some of it's not. Ding, ding, ding. There's your problem. And I said, some of it's true and some of it's not. Like it's, you know, it's a book. It's a fiction book, not a fictional book. It's a fiction book. Like, and then I said something like, the media is going to go crazy. Like you have to tell, I don't remember who I said, somebody about doing like media and like had posted like this picture of the kids. So I was like, you posted that? Like, this is crazy. Like, get me out of prison, blah, blah, blah. Like, get me out of prison, blah, blah, blah. It is this long thing. And that's what they nitpicked. Do you have like all the other pages? Yeah. Does Sky know this? Yeah, I told her. I gave it to her. Oh my God. I know. I gave it to her and I showed her the front of it and I was like all in my Sky folder because I didn't know how much I can say. Like I don't, because it's all just, some of it's true and some of it's not and some of it's altered. Like it's just, I don't know what I can and can't say like in this book, you know? So obviously, yeah, it's fiction if I'm in a Mexico prison and we're already going to trial and he says, and dad's alive. Like, yeah, dad's, yeah. And so I have like all of the pages like bent, like, so they go together, you know, like it's very clear. Uh-huh. Nothing is clear. Like, oh my God, nothing is clear. Nothing is clear. Nothing is clear. Nothing is clear. That these pages go like, this is together. And then on the front of it, it says like the title of the characters, like, because I didn't change. On the front of everything, I had like, your name's Vinny. I don't know why, but I have like all characters and then what their names are going to be changed to. But like when I'm writing, it's like confusing to think like, okay, wait, who was Stella? Who was, you know, oh good. So there's like a key. of like the names she's trying to change. Good. So there's a key on it for like Vinny equals brother. Good. It'll make it much easier for the prosecutors to figure out who you're talking to. And when they show it to a jury, they're going to be like, okay, so she said Vinny equals Ronnie. Same. Oh, yeah. So I use all of them and then go back and change them to the names that are on the front of the freaking book. And it even says like the title, these are chapters and these are the characters. Are you fucking serious? Nothing on this can be used against me. Like, this is all a mystery fictional book. That's just not happening. It's all, which makes sense because like the girls said that they had like checked my cell like 6 times. And one of the times they spent like 2 hours. And I was like, so they were reading through the whole book. They must have been fucking riveted. They were tossing your cell. Yeah, they knew what the hell they had. Yeah, they knew it was a fucking bullshit book. She's saying in this phone call, half of it's real. Yeah. And they're like, oh no, looks like it could be de creme de la creme. Taking a pause real quick because Jicky asked a great question. Are jail calls electronically transcribed? They are electronically recorded. This was provided to somebody to transcribe them. When I was a law clerk, that was part of my duties, was transcribing jail calls. Even as an attorney, I would occasionally transcribe my old jail calls. We wouldn't always send them out for transcription, depending on what we were using them for. But when you need to present them in court, you need to have them transcribed. I guess you can provide them in audio, depending on the timing. Kouri Richins. This looks good. Yeah, decriminating. Do you mean incriminating? Do we mean incriminating? Because I feel like incriminating is the word that we're looking for here. It might have just been a pronunciation thing. I'm not going to judge. I pronounce shit fucked up all the time. Kouri Richins, yeah. Ronnie, yeah. Let's see this one. Oh my fucking God. I know. That's why I'm telling you, this is insane. Like, there was never a letter. There was never a letter in a book, in an envelope. Like, there was like, this was never a letter. Like, what the fuck are you talking about? Does mom know this? Yeah, I told her, but she was like halfway listening. And I'm like, Mom, I'm trying to get out of prison. Get out of prison. When did you tell her? A couple of days ago. Oh, no, the first day. I think it was the first day when I got locked down. Well, she clearly was not listening because she has not told me that. She wasn't listening to you at all. I don't think she was like, and I'm like, Mom, are you hearing what I'm saying? And she's like, yeah, so anyway. I wonder why. I wonder why that's happening to you. I wonder why. And she's like, yeah, so anyway. And I'm like, oh my hell. I was like, okay, so I don't know if she told DJ. I didn't know if she told you. I didn't know, but Sky has the freaking book. No, this is the first time hearing about it. Yeah, it was pretty interesting too. Like, they go and we're like, holy shit, that's transcribed. So they go and we're like, I've been transported back to junior high. So, and they were like, and then we go, and then they would go, and then we were like, and then dude. Yeah, it was pretty interesting too. Like, they go and we're like, Dad and I, like, we're hunting, and we like, the Mexican guys were like up on the cliff, and we have to pretend like, you know, like, how are we, like, Ronnie, it's such a detailed book. I'm not shitting you. Like, what the fuck, man, is happening? And then like, then we found out Marco, the guy in the kitchen, is the one that sells the pills, and we get some from him. But then there's like all these like 15 and 16-year-old girls that are there, like getting human trafficked because they have this like 4th of July party. And like, I'm sorry, what? Wait, did they have a 4th of July party? That doesn't make any sense. Ronnie, exactly. Babes. 4th of July party was not the thing. It's not the thing. It's not the thing. It's not the thing. It's not the thing at all. Polly in the chat said Marco the narco. Yes, that's exactly what it is. That's exactly what it is. Nico said face desk. This is the only part Rodney is confused by. Rodney's like, sis, so there's no like that. That doesn't make sense. Your fictional story is not fictioning properly. Ronnie, why did they have a 4th of July party? That doesn't make any sense. He's just putting his foot down here. Kouri, yeah, I know. And it even says in there, like, we like Mexican, like, we don't know if they're gonna have a party. Ronnie, like an Independence Day? Because we're in Mexico. But, because I had just gotten like released on the detention hearing and I wanted to get to Mexico like right ASAP. So it was like we were even getting to Mexico like on the 3rd. And then like dad says, well, this will be perfect. Maybe they'll just celebrate anyway. And that's when like the party and drugs will come out. And I was like, okay, cool. Good idea. And then we find out that they really are having a party, like, and they bring in truckloads of beer and all this stuff. But really, it's just a party. It's a sale of like human trafficking girls. Yeah. And I write how like all the guys and women are dressed to the T, but then like they have these like 15 and 16-year-old girls with them and that are like their makeup's running down their face and they're like, you know, like rocking back and forth. Like you can tell they're so drugged. And then I overhear a conversation with some guy that says, hey, I'll give you 10 grand for that girl. And that's when I find out. Ma'am. Like it is really, oh my God, no, dude, everyone is blowing apparently. I don't know what you know. I don't watch the news, but no, they're like all blowing up about this. Ronnie, she's not listening to you. She wants to tell you about human trafficking at a 4th of July party in Mexico. That like, she's not done yet. Kouri, yeah, like Ronnie. So that's fucking unreal. Kouri, like at one, you know, at some point, I hope Sky's going to say like what it really is. I'm sure that she will. I don't think that anybody knew. Like mom told me this as I was going in to do. I was a little busy and I was like blowing up. And then I got a call from a reporter and I was like, I don't know what the fuck you're talking about. Like I was pretty damn pissy with them because like instantly asked. And I was like, how the fuck do you even know about this? And she was like, well, they're talking about this and this and that. And I was like, what are you talking about, dude? I don't know what you're talking about. Like, I got pretty shitty with them. Kouri, Ronnie. But yeah, no, like apparently you're it's all over the damn place. So, I mean, that's really good now. I'm sure that Sky's going to come out and say it. I hope so. It's even like dated back to when, like, it's just so crazy how like out of context everything is. Yeah. And it's like, oh, you took these pages, but you forgot about the rest of it. Well, duh. Right. Like, yeah, no, it makes Sky's thing was actually really good. Like they did it illegally, first of all. Second, the gag order doesn't it's like already out in the public docket. It's already out in the public eye. Like they're trying to fuck her entire trial. And even if this comes out, you know, even when it comes out as being a book, like, well, still like they're trying to fuck her entire trial and taint a damn jury. They're gonna taint again. I mean, okay. Kouri, and it's so obvious that's what they're doing. Kouri, right? Because they're that desperate. It's just unbelievable. Kouri, and that thing you were looking for the other day, way to be vague. And that thing that you were looking for the other day, they did not do it. I'm telling you, it was not done intentionally. The thing I was looking for the other day, yep. Oh, I really want to know what inaudible is. Ronnie, they didn't do it intentionally. Kouri intentionally did not do it. No, they did. They did intentionally? No, not do it. You just said they did not do it. Yeah. It was never done. That specific thing was never done. And they made sure it was never done intentionally. Yeah, that is bonkers. Yeah. These fucking morons. Because if it was done, it would show, you know, that they fucked up. Holy shit. Yeah, I can't. No, she didn't. Huh? Go ahead. No, I knew she wasn't like paying attention when I'm like trying to tell her, but you know how she does. Oh, they're talking about mom again. Yeah, well, mom was just on the phone with Sky and she said, you're not allowed to call her anymore. Kouri Richins. Wait, what? Mom was just on the phone, or mom texted Sky saying, hey, this is what Kouri can't text for 90 days and do this, that, and the other, whatever. I just want to let you know. And I guess Sky told her she can't talk to her on the phone anymore. You on the phone anymore. Kouri, what? She just barely said that. Ronnie, yeah. And I was like, what did you say back to her? And I was like, well, no, think again. She goes, I didn't do anything, but mom did not hear you worth a damn. She definitely was zoning out when you said that. Otherwise, she'd have said something if she's still referring to it as a letter. Kouri, oh my gosh, it was never a letter. It's not about the pasta. It was never a letter. Oh, I love reading transcripts. Ronnie, I know this is fucking Kouri. Well, you'll have to explain it to her. Ronnie, I'm going to call her as soon as I get off the phone. Well, it's going to hang up in a minute. So I just wanted to check in. Tell her, well, cool, to don't freak out at Sky. I'm not. That's all. I was like, so she had like this whole thing that she was going to write. And I was like, no, just say nope. Think again. Sky's going to file whatever she wants, but you can't tell a mother not to talk to her daughter. Who else is she going to talk to all day? Kouri, yeah, I get it. But all right, well, you can give mom a call. I'll let you go. Ronnie, okay, I'm going to call her right now. Jesus. Kouri, okay, love you, bye. Love you, bye. Did y'all pay for the roller coaster we just went on? Anybody a little motion sick? I really wonder what Sky's conversations are like with this defendant. Because she's like, no, it's like a book, but we liked it. Oh my God. So Kouri Richins is writing a book about a 4th of July party in Mexico. And that is the heart of her conversation with her brother. The reason the prosecution put this letter or put this transcript of the call in is to show the court that Kouri said to her brother, parts of it are real, but parts of it are a fictional book. It further goes to show it's not privileged communications with her lawyer. And it further goes to show that there is some veracity to it when she's saying parts of it are real. Again, Kouri Richins has gone a long way to fuck her own case with all of this. Woo, baby. This is bananas. Shall we take a look at the defense allegations of prosecutorial misconduct now that the prosecution is alleging that the defense has smuggled things out of the jail? Let's do that. Let's just Kouri. What is even happening?
What is even happening? What is even happening?
Her 65-page book. I feel for her lawyer. Look, man, but where did the white strips come from? Like, how did she get the white strips? I need inquiring minds. I have questions. All right. Motion to dismiss due to prosecutorial misconduct. I can just hear the tennis match. It's like, defendant Richins, by and through counsel, brings this motion to dismiss. Relief requested. Defendant seeks an order dismissing all charges against her because the state is engaged in prosecutorial misconduct such that a fair trial in this case is no longer possible. Look, man, if they could find a jury that hadn't heard about Depp v. Heard, they're going to be able to find a jury that hasn't heard about this. Alternatively, the court should enter an order that 1, disqualifies the Summit County Attorney's Office, 2, changes venue from Summit County to Salt Lake County, 3, suppresses all evidence related to the walk the dog letter, and 4, provides for a jury instruction to preclude consideration of the state's false claim that Ms. Richins has engaged in witness tampering. That's way early to ask for a jury instruction to preclude consideration of the state's false claim. You could try to get the state to not make that claim. But where do the white strips come from? Procedural and factual background. State's motion for gag order. On May 31st, 2023, the state filed a motion for gag order, which asked the court for the imposition of a gag order in response to the unanticipated and overwhelming media interest in this case. The state argued that the relief requested was necessary to protect Richins' right to a fair trial in a court of law, not the court of public opinion, and highlights the importance of avoiding pretrial tainting of the jury pool. We just love this word. We're going to celebrate how many times the word taint can come up in a given fucking motion, because man, oh man. Quote, this case should be tried in a court of law on the basis of relevant and admissible evidence, not in the court of public opinion on the basis of uninformed or inaccurate sensation, rumor, and hearsay. Or novels about the 4th of July in Mexico. Your mileage may vary. In this case, observation of the defendant's presumption of innocence and protection against pretrial tainting of the jury pool should be paramount. The state also acknowledged that the circumstances of this case, particularly as it relates to media coverage from global media outlets, dramatically increase the risk of tainting the jury pool. The Summit County Attorney's Office has been contacted by numerous global media outlets, including in alphabetical order, and among others, ABC, BBC, CNN, Court TV, The Daily Mail, Dateline, Good Morning America, The Buffington Post. Please tell me they're still typoing the Huffington Post. I appreciate it. The Buffington Post, Inside Edition, ITV, Great Britain. I've been on ITV. They're lovely. NBC News Nation, The New York Times, Paramount People, The Rolling Stone, Telemundo, The Washington Post, and USA Today. I need to ask. I have questions. Baker Media has questions. At least 4 filmmaking organizations on this continent and in Western Europe have expressed their intent to produce a documentary. Oh yeah, I'm sure those are already in the works. A quick Google search reveals exponentially more media outlets have already reported on this matter. In addition to the outlets listed above, these include, but are not limited to, the AP News, CBS, Entertainment Tonight, Euronews, Fox News, The Independent, Insider, The New York Daily, my brain just stopped, The New York Daily News, The New York Post, Oxygen, The Toronto Sun, Yahoo News, etc. This in the first few weeks after this matter was filed. I am offended that they list none of their regional outlets. Their regional outlets are fantastic. On June 2nd, 2023, in response to the state's motion for gag order, the court entered the order that inter alia requires compliance with Rule 3.6. Among other things, the gag order prohibits the lawyers in this case from making any extrajudicial statements. Is this motion just going to rehash the motion for sanctions? Keep reading. The state publicly accuses Ms. Richins of witness tampering while admitting it has no evidence that such crime occurred. Yep. On September 15th, 2023, the state filed a document titled Walk the Dog Letter on the public docket in this case. The state did not file the letter pursuant to any rule of civil procedure. Yes, they did. It's clear that it's an exhibit. All right. Along with the Walk the Dog letter, the state also filed a police report on the public docket in this case. Police reports are not admissible evidence, stating police reports lack the necessary earmarks of reliability and trustworthiness and are therefore inadmissible. The police report describes the search of Richins' cell and the discovery of the letter. It was for context in relation to the location of the Walk the Dog letter for the motion for the no contact order. But anyway, the police report states that the letter was folded and placed in the middle of a book located in Richins' cell. However, the letter does not appear to have any crease marks that would indicate it was ever quote unquote folded. The report also omits a critical fact, namely that the letter was physically bound to notes from Richins to her counsel. This was not communicated to defense counsel until October 2nd, when defense counsel specifically asked about the notes during the Zoom conference with counsel. In an email following the Zoom conference, the state confirmed the notes had the word sky at the top and were bound with glue as if ripped from a notebook or legal pad to the walk the dog letter. That's an interesting bit of information. Rather than finding the letter hidden inside a book, the state apparently obtained the letter through potentially illegally searching Richins' documents, which would be a problem, which were stored in an envelope titled Sky. That's not necessarily privileged. The jail is allowed to search through stuff, and if it's privileged, that goes to the lawyer and the other stuff doesn't. The manual provides that legal pouches may only be inspected to determine whether or not the pouch is being used to hide contraband, and non-privileged stuff could be considered contraband, but these weren't in a pouch. In addition to the walk the dog letter, the state also filed a motion for no contact order. The opening sentence of the motion states a no contact order is necessary to prevent defendant from further engaging in witness tampering, alleging that the walk the dog letter is witness tampering. The state has never charged Richins with witness tampering, much less convicted her of such a crime. In its motion, the state admits it's currently unclear whether Richins disclosed the letter to the mother. The state references yet another letter. We know all this. This is very rehashed. However, the state admits it does not know the contents of the letter from September 13th. The state claims there is a strong inference that the letter was destroyed or flushed. The state has no actual evidence. Media coverage of the walk the dog letter and motion for no contact. Within minutes of the state filing the walk the dog letter and motion for no contact, defense counsel began receiving requests for comment from media outlets. By September 18th, countless media outlets had already reported on the walk the dog letter and were parroting the state's claims of witness tampering and attempts to compel false testimony. See media coverage screenshots. The local and global media outlets that covered the alleged witness tampering include, but are not limited to, CNN, NBC, Fox News, CBS, ABC, People, The New York Post, The Daily Beast, Huffington Post, KSL, KCPW, KUTV, and Fox 13. Hey, there's the local media love. Well, we appreciate it. Argument. The court can dismiss criminal charges when prosecutorial misconduct results in a denial of due process. Let's see what their argument is. To constitute a denial of due process, the misconduct must be of sufficient significance to result in the denial of a defendant's right to fair trial. Due process requires that the accused receive a trial by an impartial jury free from outside influences, including pretrial publicity. They are arguing, so the defense is arguing that the marking of the letter as an exhibit or the leaking of the letter is tainting the jury pool, denying her of a theoretical fair trial down the road. Here, the state has violated Richins' due process rights by falsely and publicly declaring that she is guilty of witness tampering. Making matters worse, the state attempted to support its false narrative by filing inadmissible evidence, including a police report, on the court's public docket. The state's misconduct has resulted in widespread publicity, such that a fair trial is no longer possible. This is not going to fly with the court at this point. Accordingly, dismissal is warranted. And then they go through the ethical duties. I want to get to the screenshots because this is largely rehashed from the motion for sanctions. The state violated its ethical duty by falsely claiming that Ms. Richins is guilty of witness tampering. And this is all rehashed. The state's recent filings include inadmissible evidence that creates a substantial risk of prejudice, including the walk the dog letter. In an email following the Zoom conference, the state confirmed that the note had the word sky at the top and were bound with glue. Arguably, the privileged nature of the attachment makes the entire letter admissible. That should be explored. That's very interesting. The police report also states the walk the dog letter was folded and placed in the middle of a book located in Richins' cell. However, the letter does not appear to have any crease marks on it that would indicate it was folded. Rather, finding the letter hidden inside a book, the evidence suggests that the state obtained the letter through a potentially illegal search of Richins' documents, which needs to come up, but that's not necessarily misconduct. That goes to search and seizure issues. The state's misconduct violates the right to a fair trial. You can't even know that yet. We are way too far out for that. They go through case law on this. I'm going to get to the conclusion and what they screenshotted. I don't think this is going to fly at this time. I think there probably will be additional motions regarding the argument over the search and seizure. For the foregoing reasons, the court should dismiss all charges against Richins. Alternatively, they should enter the orders that were listed above. Let's see what media has been highlighted as exhibits. Exhibit A, the motion for gag order. We've already gone through that. Exhibit B, the walk the dog letter, now filed again on the public docket, just in case anybody didn't have it. Exhibit C is not loading. What is Exhibit C? Oh, it might be redacted. Nope, that's the envelope. Sky Lazaro, attorney privilege, and we've seen those pictures before. Exhibit D, motion for no contact order. We've gone through that motion. So is the court. Exhibit E. My computer is now struggling to load things. Excuse me. Today Show, or the Today.com. New twist in Utah murder case. Kouri Richins allegedly tried to get mother to give false testimony. She tried to get the mother to get the brother to give false testimony. That's not as catchy of a headline, though. Letter was intended to instruct Richins' brother to testify falsely that Eric obtained drugs from Mexico. That is from the prosecutor's motion. Today, witness tampering. Kouri Richins allegedly tried to get mother to give false testimony. 2. From Today. Children's book author who was charged with killing her husband now accused of witness tampering. Utah grief author accused of killing husband with fentanyl asked brother to testify falsely. State says they attribute it properly. Kouri Richins, Utah grief book author who allegedly killed husband accused of witness tampering. I mean, it makes it clear that she's accused of it. It doesn't say that she did it. It says that they're accusing her of it. Exclusive. Kouri Richins, a Utah mom and book author, accused of poisoning her husband with a fentanyl-laced. That doesn't even get to it. Letter found in Kouri Richins' cell outlines false testimony for her mom and brother, prosecutors say. I mean, all of those headlines make it very clear that this is an accusation, not that it's been proven. I don't know. What do you guys think? I think these headlines are more clear than the ones about Joe Jonas and Sophie Turner's divorce. And that's it. The real question from the Aussie Insider: where are the white strips and how did she get them? And what's going on with glue? Grief author, yes, because she wrote a children's book about grief in the time after her husband passed or was killed and the time that she was arrested. And she had done a couple media appearances for that book called Are You With Us or something like that. So to summarize, after 2 hours and 45 minutes of streaming, to summarize, let's do a cute summary. The defense is accusing the prosecution of misconduct with relation to their filing the motion for no contact order and filing the walk the dog letter on the public docket, and also accusing the jail of illegally searching Kouri Richins' belongings because some of those might have been attorney-client privileged information. The walk the dog letter clearly is not. The state is accusing the defense of taking contraband out of the jail by taking letters that were not privileged material out of the jail, and is asking the court to force the defense to turn those over, at least to be reviewed by either the taint attorney or the judge for attorney-client information. But we know from the jail calls that some of that is a 65-page manuscript of a novel that is kind of true, kind of not, about everything that happened up to the bail hearing. So we have a lot going back and forth, and we still have the heart of this, which is the motion for no contact order. It looks like that is going to be heard right at the beginning of November. Hopefully that court hearing will be recorded. It will be very interesting. If I can stream it, I will be out of town, but if I can stream it, I will absolutely stream it. It might be a hotel stream, but the way I want to know what happens with this motion for no contact order, because this case has gone all the way off the rails. It is a roller coaster of stuff aside from the murder case, and it is definitely busy and has been busy, and we are going to keep checking in on this case through trial, if it goes to trial. So when is the preliminary hearing? Can we do that? I'm very curious. I want to do that. All right, with all of that, law nerds, we've got questions, you've got questions, I've got questions, we've got questions in Audacity today. So it's time to fact around and find out. All right, everybody, thanks for hanging with me. I have one hair that is just, it wants to go north. Stop it. I don't need one, just the one that's like, whoop, this is what we're doing. All right, let's get to question chat. This is so wild. So wild. Tati updates. I did not have time for Tati updates today. We had a lot of breaking news. We will do Tati updates soon. Don't worry. Soon. I promise. I used white strips after 6 years of braces and they were decent. They are decent from removing the tint from your teeth. Will Judge Newman be affected by the jury tampering if true? I need more information because it happened in his court. It seemed that the clerk did say that she inquired of a juror that he knew about. I don't know what he was expected to do with that. It might affect him most immediately in that he could end up being a witness and not able to hear those evidentiary hearings. So, yes, Tainted Love was done by Soft Cell. So they untaint your tainted teeth. They all the things. I have still some purple in here, but it needs to be refreshed. But I am due for a whole hair day before I go to BravoCon. So I'm just letting it be till then. I'm going to get to some of our super chats and member chats in chronological order. So some of these are from much earlier. Ashley, good morning. I've missed you. We miss you too. My twins came 6 weeks early and have been in the NICU for the last 5 weeks, but both babies are finally home and doing well. Congratulations, Ashley. I am also a NICU mom. It is tremendously stressful. It is one of the hardest things you will ever do in your life, but I am proud to say that my NICU kiddo is thriving as a very sassy teenager. So it is a very, very stressful time. And then sometimes having them home is also stressful. It's like, now what? So congratulations. I'm so happy your twins are home and you guys are getting to get into the day-to-day of being home with twins, which is not an easy task. Murdaugh granted retrial hearing. Murdaugh's appeal was stayed so that they can do a hearing with regard to whether or not the alleged jury tampering warrants a potential new trial. So yes, an evidentiary hearing. Eating Jimmy John's at my desk while wishing the sub was 2 inches shorter and $2 cheaper. First world problems. Makeup Maven, fair enough. It's going to be time for lunch for me soon. Hello, beautiful. I've have missed you, brightening my world with your insights and expertise. Well, hopefully it was worth it today, Babs. We did a dramatic reading of transcripts. I hope that it brought some joy and levity to a very heavy case. SC Court of Appeal in abeyance. Parties to update every 30 days. Thank you, Victor, on the Murdaugh case. Elena said, I got my own screaming goat for my office. My coworkers love it. Got your water. I've definitely got some water too in Corpus Christi. Thank you for the update. The screaming goats are so needed. I bought the Travel We Live Here mug with the discount. Fantastic. That is in your Law Nerd app. But we also have the giant We Live Here Now mug. We might need this for the Richins case. We might need this much coffee for the Richins case. Got my university sticker, Law Nerd. Yes. The stickers are so fun. I love them. Andrea, can you wish my niece Lydia happy belated birthday? She turned 4 on 10/4. She loves you. Lydia, happy birthday. I hope that you grow up in a world where you do not say like every 7 seconds. That's fantastic. Happy birthday. Thank you so much. Savvy Writes Books covered her YouTube presence. Savvy Writes Books does such incredible content. I will absolutely go take a look at that. Anyway, interesting, always informative. I hope so. Sniperwolf is here in Arizona. She crossed state lines to go to his home in California. Interesting. She did say that she did say that the home in California was near where she was shooting something. So it seemed like it might have been incidental to the home, but that could cause even more distress. But what if their home is also their office? This is going back to talking about public doxing. If you are a content creator and your home is also your office, but you list it as your office address, that generally is publicly available from everything from the Secretary of State and other places. But if it is not listed as your office address, then it is your private home address. I suggest all offices have some type of address separate and apart from their home address to use. So when I did a lot of business consulting, one of the first things I said was, do not put your home address on your LLC filing forms or anything else. Do not put it in a way where it becomes publicly available. Thank you, Stephanie, for the love for the hair. Cold foam, cold brew for me. Palm Pilot family here. Look, the way I loved my trio, I loved it. I loved it. I loved it so much. I loved it. They were so good. I wish I had kept one. How do you cope with the death threats? I work for a nonprofit and started getting them, and I'm not sure how to cope with them other than to contact the authorities. I maybe one day I should talk about the things that I do, but hopefully your organization has support for you, not just to contact authorities, but your organizational support to help track down where those are coming from and why. But also you need your own support to process it. It does feel threatening. Our bodies do feel threatened. It's not something you ever get used to. It is something that takes time to deal with in parts because you do have to assess the threat, especially if you work at a location that is publicly known, an open business location. It is something I worried about at the DA's office when Dr. B's dental office was easily findable and public. It's concerning. People going to workplaces to cause harm is concerning. So sometimes private investigators can help unmask people and remind them that they are not anonymous. There are lots of options there, but also for you, it's not unreasonable to ask your job to provide you with support in processing it. It's not a normal thing to deal with, and it's fuckery. And sadly, it can't just be written off as like internet drama, because too frequently that can become serious. And in the small percentage of chances it becomes very serious, you need to make sure that you are protected. So it is not easy to deal with. Hopefully that helps. And that's something, if we want to talk about more in other content, we can. But hopefully your nonprofit will support you, and it might be that a investigator is needed to do that. PIs can be very, very helpful. And going to the PI first and then taking all that information to law enforcement can help law enforcement when they don't, depending on law enforcement, don't always have the resources to track down who's doing it behind IP addresses. Stephen A. asked, how does the Castle Doctrine play into doxing laws? This is probably a much longer answer than the question intended it to be, but it very much depends state by state. Different states have different types of when you need to retreat, when you don't need to retreat. Castle Doctrine is generally referring to what level of stand your ground you can do at your home, if you're required to retreat or not retreat. It is always my opinion that if someone is outside your home trying to get in, that staying inside your home and calling the authorities and making sure you have cameras and things like that is the appropriate thing to do. So standing your ground very much, and self-defense law very much changes state by state. You have to understand the rules in your state, because opening the door and chasing someone down in a lot of states is not going to count. But if somebody's breaching your door in a lot of states, that will be valid use for self-defense. And then the level of defense that you may use varies. I always recommend people have varying levels of deterrence, from things like pepper spray and other weapons up. It just depends on your state, it depends on your family, and it depends on your circumstance. So know the rules in your state. So how do those play together? It really, really depends on the rules in your state and the situation. So I think the best way for castle doctrine not to come into play is for people to not go to people's houses. Don't do that. If you're not delivering food or packages or invited, don't go to people's houses. I don't know if I can make that any more clear. Deborah says, I'm from Detroit. That's dangerous. We live in times where just indiscriminately knocking on somebody's door does not go well. There was a series of incidents where people were shot and or killed for knocking on the wrong door. Do you guys remember that? There were a number of cases that all happened like in quick succession. And some of those I was like, what the fuck is happening? It's different when you have somebody going back and forth with you online and then they post on social media, should I drop by this person's house that's close by? And then they drop by and video it. It takes it up so many levels. I don't think anyone should be harmed pulling into the wrong driveway. But if you are going to someone's home and you have done all the other things surrounding it, I can see where that could go badly. And I can also see where others might take up that call, even though they shouldn't. And I haven't seen anything that shows that Sniperwolf has said to her audience, leave this between us. Joe Jersey said, I'd be the petty creator and start critiquing your critique channel, money to be made. And some creators are definitely going to do that. The amount of info you can Google is insane. Yes, there are ways to get rid of that, but some ways are easier than others. Technically, the dark web is on the internet. Yes, it is. Love the honored community. Same. Thank you for more gifted memberships. I'm going to be watching Special Forces tonight. I did not get to it last night. Mondays are always really hectic for me. I always need more information. Me too. I despise laundry and dishes, just saying. I mean, I definitely sometimes don't get laundry where it needs to be. And right now, most of my clothes are on top of my dryer, but they're dry and clean. Love my laundered family. I wear my I Have Questions shirt and the pumpkin patch over the weekend. I got so many compliments. I love it because don't we all? Don't we all have questions? Tinsley, good to see you. I literally just laughed out extremely loud at your sweatshirt. Please give us the link for it. It was a gift. I have no idea. I have no idea where it came from. I will Google around. Margaret said during initial police response, didn't she say that she and Eric were the only adults in the home and denied that Eric had substance abuse issues? Yes, and that came up in the prosecution's motion. The article isn't about Johnny, but I wrote the article about Johnny. Yep. My husband leaves for work at the crack of dawn, so on days we can sleep in a little longer. We say we get up at the taint of dawn. That's very funny. I love it. Motion for Darth Vader and squeaky voice changer.
We definitely did some of the squeaky voice changer, and then we just did some of the Emily Valley Girl.
It was wild. We definitely believe you, Kouri. 60 pages is a soups long book. You are definitely on point with the reading of the transcript. So good. Thank you. It's a level of nonsense that I haven't seen. Oh my God. Miss Freddie. Wait, Kouri is saying she wrote fanfic of herself. Yes, that's exactly what it is. She has fanficked her own case. That's exactly what it sounds like. Yikes. The first 6 chapters, are they 4-page chapters? Yep. See, I mean, if the maths. I feel bad for the transcriptionist. Yes. The court reporters go through so much. So listening to it on tape and being able to pause while you're doing it would be easier. When you have the little foot pedal that you can pause audio and transcribe, it's actually pretty fun to do. I did a lot. I transcribed a whole hostage situation when I was a law clerk. It was so many hours and hours and hours of audio, but I was with my little foot pedal, I type fast. I don't mind typing either, so I enjoyed it. Deb said, it should be Cinco de Mayo. You're so great. Love your reading. Thank you so much. 17 months. Thanks for keeping me company. I will always keep you company. That's what I'm here for. Novels begin at 50 to 60K words long. Writer shade. It's a short story. Maybe it's a children's book about human trafficking. Hey, EDB was enjoying the members only podcast when it suddenly went poof. I'm always asleep when those are recorded. I'm so sorry. They do that. They go private, but it'll be up tomorrow. Again, it will be live, and it will be live at like 4:45 a.m. Good morning from Maryland. Good morning. The real question that need answers: did you buy bacon yet? No, I haven't had a chance to go to the store. I'm still out of bacon. It's unacceptable. Can you explain who, what, where, why, taint lawyer? I could write fanfic about who, what, where, why, taint lawyer. But generally, they are another lawyer who is not related to the case in the serious answer. They are a lawyer that is not related to the case who will review documents to see if it's attorney-client privileged and decide if it can be turned over. So that is the real answer. It's my birthday week. Love the taint. Lizzie, thank you for sharing all that information about yourself. And many more happy birthdays to you. Tainted Love is a cover originally by Gloria Jones. I had no idea. Thank you, Will. Loading the dishwasher, unloading is also a thing. My kids unload the dishwasher. It's glorious. I feel like there are some parenting wins that I have, some not so much, but that is one of them. My kids know how to unload the dishwasher and do it well. 1 whole year. Did you get Dave tickets in South Carolina? Yes. Yes, I did. I will be there. I will be there with one of my ride or die friends. Will asked, will you be covering the Sssniperwolf versus her ex-husband Evan Sausage lawsuit? A lot of you have asked. I know Atuzi has been covering it. A lot of you have asked about it. We can look into it. Here's what got me with that particular video, that particular case. The request for derivative demands are very interesting to me. Because we dealt with them briefly in the Toddy Westbrook case when it was still in California as well. There are some really interesting conversations about derivative demands when a company is suing and what they're suing over. So it's fun. Lindsay, will you be in the correct Carolina? I booked the correct hotel. I still need to book my flight. The beginning of November is going to be insane. And I am going to be hopping from Vegas to Carolina, back to Vegas. It's going to be very Vegas-y and very busy. Thank you for covering the JackFilms situation. You're welcome. I'm excited that we've got stuff planned in Vegas. I'm really, really excited. And I get to go see Yachtly Crew because they're in their residency in Vegas when I'm in Vegas, and I can't wait. It's been too long. The Danish doll, Emily, thank you for keeping me sane during pregnancy. You're welcome. It is a different time. The insanity is not you. Hormones are a bitch when you're pregnant. Rando from Iowa, like for real, like this is totally insane. Oh my God, I know, right? Like for real, like she was all, and then he was all, and then she was all, and then I was like, oh my God, no. All of it. Your hair looks awesome. Thank you. Kiddos AP courses are going decent. Any new stories? For me, all of today. It's mammogram day. Wish me luck. Good luck. May the squish go well and everything be fine. Yay. Love the way you say Vegas. Vegas. I enjoy Vegas, but there's a definite plus minus on Vegas, like how long you're there when you're visiting. There is for sure a too short and there is for sure a too long. So I am going to be back and forth for sure. So somebody said make sure to book your flight for Charlotte. I will not be booking my flight for Charlotte. Dave is not playing in Charlotte. He's playing elsewhere in South Carolina. I will be at the show elsewhere in South Carolina. But yes, I will be in South Carolina. No, I did not. For everyone who has asked, and a number of you have, and I love you for it. I don't have a passport yet, so I can't go to Dave abroad yet because I don't have a passport yet because my passport expired because I'm ADHD. So we'll see what happens. That's not what I was trying to do. Charlotte is North Carolina. I'm not booking my flight to there either. Yachtly Crew. Jolene, Yachtly Crew is a fantastic yacht rock band that I very much enjoy. And they have a residency. They play certain weekends in Vegas. And one of the weekends I'm in Vegas, they will be in Vegas. I have not seen them in, God, it's been almost a year because it was during Abby's campaign that we went to see them at the Whiskey in LA. And they play amazing. They play just amazing yacht rock music. And their Yachtly crew is like Law Nerd-esque levels of fun. It is just absolutely fantastic. And I love it. I love it. My sister-in-law loves them. They're so much fun. Their shows are so much fun. It's just a really good time. I love live music. I love good live music. They are great musicians, and it's just a lot of fun. Enjoy the time in South Carolina. We love our state. I love your state too. It's great. Did you read transcripts as a DA in the same style? In my brain, yes. If I ever had to read transcripts in court, no. Surely the pun would be Yachtly Crew. Any updates on Jeff Wittick, David Dobrik? Not yet. Today we are done. There is more to do. Much more to do. Elena said Cinco de Mayo is about the Battle of Puebla. Most Mexicans don't celebrate it. I'd be Diez y Seis de Septiembre if you want. You want Mexican Independence Day. Kouri would probably say same difference. I mean, yeah, probably. So going to Queen and Adam Lambert next month sounds amazing. I love live music. I really do. So I definitely try to keep live music in. I am interested to go see the Sphere in Vegas as well. I don't know if I'll have time to go to a show. BravoCon is always so busy. I don't know if I'll have time to go to a show, but I will be interested. Did you have to write Amazing Sass in Lawyer Life? I didn't write a ton in Lawyer Life, and there were definitely times early in my career where I was afraid to be too sassy. So was I always incredibly sassy and witty? No. Did I like written motions? No. Was I a bit sassier when I was in trial? When it was appropriate, but sometimes sass from the prosecution can come off too heavy-handed, and I always wanted to make sure that I was not coming across as too heavy-handed. I also didn't want defendants ever to feel like prosecuting was a joke, that it was not a heavy thing. So I really tried to tone it down. There were some defense attorneys, though, that got under my skin. I'm sure there's defense attorneys who I got under their skin. But it was funny, when the Netflix thing came out, there were some defense attorneys I had worked with who reached out and were like, I saw you on my TV. I heard you. I miss you. How are you doing? And it was really nice to catch up. I got along with most of the attorneys I worked with really well. There were some, but there's always some in any profession. And there were definitely times where I would hold a line just stubbornly. Be like, no, this is what we're doing. This is what the victim wants. So with all of that, Law Nerds, it has been over 3 hours. Thank you for being here. Thank you for being Law Nerds. Tomorrow, new podcast on 8 Passenger and the updates in that case and what's going on with Kevin Franke and my thoughts on whether or not he can be prosecuted, not prosecuted, blah, 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 blah. That, all of that. Are you going to be able to meet up after Dave? Send me an email, Hunter. I am in and out of that show pretty quick, so I don't know. But I have a meetup planned in Vegas. I'll be sharing that information too. But we have a meetup planned in Vegas for BravoCon for those of you that are in the world. So tomorrow, 8 Passenger updates and an update on whether or not Kevin Franke did in fact want his older daughter, Sherry Franke, prosecuted / arrested / charged with burglary. On Thursday, I'm hoping we will be doing live court coverage. We can look at the court documents on the Murdaugh stuff a little bit more. They're probably not going to be super in-depth. It's going to be a lot of, we're pausing this and sending it back to the other court. So with everything, we will do it. Hunter, I will let you know, Law Nerds, if we are doing anything before the concert, because I will be in town before the concert. So I will let you know. All right. With all of that, I will see you soon. What are we covering Thursday? Hopefully live court and a bit of Murdaugh, it sounds like. Unless anything else pops off, because it's early in the week and it always seems to, doesn't it? Law Nerds, don't forget to download the app and get your 15% off discount. It will be pushed to your app. You will see it. It will get pushed to the app so that if you are just getting into the app, you will get it. That is ending on Friday, so don't forget to do that now. I will talk to you guys tomorrow on the podcast and then Thursday live. All right. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app,
at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.